let everybody in and then we should be able to go.
Go ahead, Alex. You can let everybody in and I'll call the meeting.
We should be all good.
All right. Good evening, commissioners. Good evening, public, staff, everyone on the Zoom. I'd like to call the Birmingham City Commission special meeting of Monday, June the 14th, 2021 to order. Will the clerk please call the roll?
Mayor Boutros.
Here in Birmingham, Michigan.
Mayor Pro Tem Long.
Here in Birmingham, Michigan.
Commissioner Baylor.
Here in Birmingham.
Commissioner Huff.
Here in Birmingham, Michigan.
Commissioner Host.
Here in Birmingham, Michigan.
Commissioner Nikita.
Here in Birmingham, Michigan.
Commissioner Sherman.
Here, Birmingham, Michigan.
Thank you, Alex. Just for the people that has joined us or joining us right now, this meeting will be considered a workshop session of the City Commission. No formal actions will be taken tonight. The purpose of this workshop is really to participate in a discussion regarding tonight. The subject is short-term rentals between commissioners, and we have a presentation by staff. I'll leave the floor to our city manager, Mr. Tom Marcus, at this time, and give us a little background and where we're here today, and we'll follow the presentation. Mr. Marcus, the floor is yours.
To unmute so I can interfere with your voice. All right. Currently, our state legislature is viewing a couple of possible bills that would impact how short-term housing is regulated by communities. I would generally characterize our situation as not having any serious issues at this time. And that's in part because we have a fairly small number of at least identifiable short-term rentals. We figure it's someplace in the mid-20s. We believe our current rental property licensing requirements apply to short-term rentals as well. And it's an observation that particularly more prevalent, this problem or issue of concern with short-term rentals is more prevalent in places with significant attractions, such as vacation destination cities, university towns with their sporting events, professional sporting event communities, cultural places that attract a lot of people into their communities for events, that sort of thing. It's not to say that we don't have some significant events. Oakland Hills comes to mind, Dream Cruise comes to mind when certain events are scheduled, and persons attending those events may seek out those situations. I've actually had some experience with short-term rental ordinances in both of the university towns that we dealt with. It got to be a real problem in Lawrence, where there were, issues of game day rentals that turned a little wild in terms of the damage that was caused to houses. And another interesting twist was that they had hotel motel taxes, and they weren't paying hotel motel taxes, and so that got to be an issue, and we had to start dealing with that. And that's an interesting issue. Typically, if this would get to be a big problem in our community, we probably would have heard from the hotels and motels that this was a concern. In a lot of places with homeowners associations, meaning condos and townhouses and things like that, they have covenants that preclude the use for short-term rentals. A condo we own in Milwaukee requires that if you're going to rent, you have to have board approval, and it has to be for a long-term use, I think, which means more than 6 months. I would say that staff has a better handle on how to find all of our short-term rentals with the assistance of some techniques that one of our commissioners shared with the staff. So we think we have a pretty good handle on how to identify them. And again, we think it's in that mid-20s. One of the things that we do believe is, like I said, that our short-term rental ordinance or long-term rental ordinance actually applies to both long and short-term. And now that we can identify those properties, I think we probably need to do some level of communication with them to let them know that we think they're required to comply with our rental ordinance that's on the books. So that's something that we will be undertaking. Bruce Johnson's going to make the rest of the presentation this evening, and then we'll have some questions as we typically do. So I'll turn it over to you, Bruce.
Hey, good evening, Mayor, Commissioners, and Mr. Marcus. Bruce Johnson, building official for the city. Let me share my screen. Can everybody see the screen?
Yes, Bruce, good evening. Go ahead with your presentation.
Okay, so this evening it's a workshop outline for the short-term rentals. I'm going to talk about the current stats for rental properties in Birmingham. And then I'll talk a little about our current regulations, our existing rental ordinance. And then City Attorney Mary Kachark will talk about allowable regulations. So the current stats for rental units in the city, apartments, we have 1,162 that are registered rental dwelling units. Single family homes, we have 470. And then condo units, there's 426. Duplex units, 50. That's where they're renting both of them. And then we have some half duplex units, which are 21. And that's where the owner is occupying one of them and then renting out the other one. At the time I put the presentation together, staff, we were guessing and estimating there were approximately 7 short-term rentals in the city, and that's ones that we had suspected when they were rented, and then looking at some of the rental sites out there like Airbnb. With the help of one of the commissioners with some searching tips, we've found that number is quite a bit higher. As of today, there are 27 listed on the sites that are out there. Of those, we have 8 that are single family homes, 2 that are either private rooms or studios inside a house, and then condo units and multifamily units, so we have 17 that we found. So the total of 27 of those. We are tracking down the addresses. We have found a lot of them. A lot of the hosts for these sites are reluctant to give the addresses, but for photos and things like that, we have found a number of them. And of the ones we've found, 4 are registered currently as a licensed dwelling unit, and 4 possible are registered. Those are the ones that are in condo buildings. We have to do a little bit more research to find those out. Next, we have a map that shows the city and where the rental units are at. In red, we see all the single family rental units spread throughout the city. And then the green are the half duplex rentals, blue, the duplex rentals. And we have the multifamily rentals, and then condo rentals in purple there. And the number shows that, there's more condos in those complexes, but 22 of those are rental units. So I'll move on to our current regulations. The city has had a rental ordinance as far back as at least 1963. Any dwelling unit in the city, whether it's a single family home, an apartment unit, or a condo, if they're going to advertise that for rent or lease, it's required to be licensed through the city to do that. And we issue an annual license. When a new rental unit comes in, the applicant must give us the floor plan for the house and then kind of a site plan, so we can establish the maximum number of occupants. That's established by the number of bedrooms. You have to have at least 70 square feet in a bedroom for it to be considered a bedroom, and that would be a single occupant. If you're going to have 2 occupants, you have to have at least 100 square feet or 50 square feet per occupant. So we look at the total number of bedrooms in the dwelling unit, and that's how we establish the occupant load, the maximum occupancy, and that is printed on their annual certificate that we issue every year. Also, when we do the review, we're looking at the site plan, establishing a minimum number of parking spaces to make sure they have on-site parking available. That is also determined by the bedrooms. For the first bedroom, they're required to have 2 parking spaces, and then for each additional bedroom, 1 parking space each. So that is also verified at the time that we are issuing the licenses. When they first apply, we do the initial inspection, and after that, rental units are inspected every 2 years. So we are going into each of the units and doing inspections every 2 years. The ordinance was updated in 2008, the last major updates that were done to it. But one of the things we did at that time was to make the landlords or the property owners responsible for any of the violations. So if the tenant has too many occupants, or if they're not maintaining the property, or parking is an issue, it's not just the tenants that are responsible. The ordinance calls out the property owner. So that's who we are going to be writing the violation notices to. There's provisions in the ordinance. If a rental property receives 10 or more violations during its inspection, we can then put it on a list to be inspected every year for the next 3 years. And since 2008, we've maybe done that a handful of times, not that many. So I think that covers our ordinance. And one of the things that I want to mention about the ordinance in general is it's applicable to a rental dwelling unit, whether it's rented on a long-term basis or a short-term basis. So right now it does work well for the short-term rentals. They are required to be licensed just as any other rental dwelling unit in the city. Speak a little bit for violations that we've received about short-term rentals. I mean, there's a handful, maybe over the last couple of years, that we've received. I think the majority of the small number we've received have been about concerns about the transient nature of a short-term rental. You know, we've heard some comments around that. But not too many complaints were loud music, loud noise, or other than that. There's been a couple of those, but we get those at any property in the city from time to time. We will get those. With that, we will move on to the allowable regulations that City Attorney Mary Kacharik is going to speak to.
Thank you, Bruce. Good evening, everyone. So as Bruce was just speaking, we have our long-term rental ordinance that is applicable to short-term, because we do not differentiate between long-term and short-term. Short-term being defined by the state is anything less than 30 days. It is a really challenging time, as Tom was alluding to at the beginning. There are 2 separate bills, one in the House, one in Senate, that was up to pass at the last Senate hearings. Both have been substituted, amended, and sent back. And I looked today, and they're both sent to committees. There's been a great deal of pressure put on the legislature now, thankfully, from the MML, having all persons like yourselves, commissioners, council members, etc., to suggest that they need to slow this down and take a better look at all of this. And the reason is because historically, municipalities have been, through the Zoning Act, has been able to regulate rentals, such as the regulations that we have. The current, and excuse me, I should back up and mention that when short-term rentals first came on the scene and became vogue, there was cases sent through Court of Appeals up to the Supreme Court, which has stated that a municipality cannot ban short-term rentals, but you could regulate them. You could regulate where they were in the city. You could regulate what part of the city, etc. There was some argument that you could regulate them out of mostly residential because it's a commercial enterprise or commercial business. Our legislature at this time is saying that short-term rentals and long-term rentals, mostly to short-term rentals, even though people say I'm doing it to make money, they have said it is not a commercial business. And therefore, most of the language about these rental bills has to do with zoning ordinances. There is some confusion then. If everything that they're talking about in the Senate bills and in the House bill is to regulate zoning, what effect will that have on our ordinance? Because it's in the general ordinances, not in zoning. Everything starts with for the purposes of zoning. Both bills start off in that fashion for the purposes of zoning. We're not zoning, we're regulating use. At this time, and what does appear we will continue to be able to do, is we will be able to inspect for codes to make sure property maintenance, plumbing, electrical codes are all adhered to. We will still be able, we can now, and still will be able to regulate noise, advertising, traffic, or other conditions for the prevention of nuisances. How many persons can occupy a dwelling, and specifically how many persons can occupy a bedroom. We will still be able to inspect and have inspection fees as we do now, and other taxes permitted by law. One of the things that's going to be up for debate is whether or not we can continue to issue permits and licenses. Through the amended or substituted bill, I should say, last time it was on the Senate floor, they sent it back with a substituted bill, and the substituted bill took out the language that would allow for permits and licenses. But again, that's through the zoning ordinance, and our ordinance is not in zoning. Our rental ordinance is in the general ordinances. So whether or not we're going to be able to continue to have some regulation, even with new language, I think we can. I think our ordinances are in pretty good shape, actually. I have taken the opportunity to compare our current rental ordinance to different ordinances that have been passed in other communities that will regulate short-term rentals specifically. And I'm happy to report that pretty much everything that we need is already here in our ordinance. In fact, some of those short-term rental ordinances that I compared to ours has language in it that most definitely will be stricken, and they will have to be repealed in those other communities to satisfy these different Senate bills that are coming forward. And then I'm happy to take questions when we come to that point, if there are any. Thank you, Bruce.
Thank you.
All right, so we can move right into the question and discussion part of the presentation. We put together 3 discussion questions for the commission to consider. The first one, what specific concerns does the commission have about short-term rentals? We'd like to kind of have a discussion about that and get a feel for concerns the commission may have.
Bruce, excuse me, if I may suggest that we take down the screen, because it's really hard to have discussion when we can't see each other's faces.
Yep.
Thank you. Yep.
If you're okay with that.
I'm fine with that.
Thank you, Mary. Commissioners, please raise your hands. I'll give you the floor, and let's go one item by one item, as we have three questions in front of us. And let's discuss the first one. What specific concerns does the commission have?
Mayor, I had a couple of clarifications on some of the presentation. Can we go to that first before we go on to other things?
Oh, sure. That's part of that. Commissioner Nikita, go ahead with your question on anything you'd like.
Yeah, I just on some of the points that were brought out. There was the chart that Bruce, you put up of the amount of rentals, the type of rentals. When you say condo rental and apartment rental, I just want to clarify what that means. Does that mean a condo building that's being rented, so it's owned by an individual and it's being rented, versus an apartment which is owned by a company that's being rented? Can we clarify what that means, please?
Yeah, in condo, I think units, that there are, think of an example, a condominium. Brookside are condominiums. If the majority of them, I don't think are being rented or leased, but if one was, that would be a condo unit that was being offered for rent or lease. And apartments like the Pearl or the 555 building, obviously they're apartments and that they're all being rented, so they are all subject to that.
Okay, that's what I wanted to just verify that was the case. I wasn't quite sure. I wanted to make sure that I understood that to be the case. I have a question about enforcement. Is that something we'll talk about after, or I'm not sure where that goes, if that's part of your presentation or if that's something we talk about after.
I'd be happy to answer any questions that you have about enforcement.
Mr. Mayor, do you want to take that after, or do you want to take it now?
I would take it now. Go ahead, Commissioner Nikita.
Yeah, I just had a question about enforcement. You were talking about short-term rental enforcement, but in terms of all the rentals, do you have a strategy to address the potential violations of some of these rentals? I mean, for example, you're referring to particular sizes of bedrooms relative to the occupancy of a home, for example, single-family house that has a certain amount of bedrooms, therefore a certain amount of people that can rent in there. How do you address when that number is, and I know this is very difficult, but that's the basis of the question. How do you address when that number is being violated because it's obviously an internal situation, or in some cases, and I know that I've witnessed this myself, and I'm sure this has come up before as well, where there's actually a rental of a home is actually being rented by, say, two families, if you will, and splitting the rent. How do we address enforcement in that way, and how do we get rid of that kind of circumstance when it's not allowed or it's not part of our ordinance allowance?
Well, I think the main point there is how do we address the complaint of overcrowding, which we've had to do a few times. And if it's a licensed rental, okay, they do have the certificate with the maximum number of occupants on there. So we would just check to verify. It can be difficult. We would start with the property owner, explain the complaint, and we need to get back in there to do another inspection that way. As far as if you had somebody leasing a single family home, say like in your example, and then they had some other people come in that were going to split the costs of that, if they weren't overcrowding, if they were within the allowable number of occupants they can have, I don't think we would even be aware of that. And even if we were, I don't know if that would be a violation. It could be of a city rule or regulation. It could be a violation of the lease agreement that they have with the property owner.
Okay, that's fine. That's fine. I think that's all I would like at this point. So thank you.
But I do agree with overcrowding. It can be potentially difficult to enforce. I can't remember the location where it was at, but it was a number of years ago when we had one and we had code enforcement, watching it, keeping track of cars. We may have even involved the police for after hours to follow it up, but we haven't had too much difficulty with that. Some of them are more challenging than others.
Thank you.
Thank you, Bruce. Commissioners, any other concerns? Commissioner Hoff, go ahead, please.
A couple of years ago, I know Commissioner Nikita and I were at the Michigan Municipal League conference where this was discussed. They had speakers on this subject on short-term rentals. And as Mr. Marcus said, there are communities that this is a real problem in, with people buying up homes and in vacation areas and renting them out short-term rentals, and it's causing a problem for their housing market. So different communities have different situations. At that time, we looked into it. Birmingham looked into it. Now, this was a few years ago, so I know the situation has changed, but it was determined that we didn't have enough short-term rentals to merit anything further. There are some companies that manage short-term rentals for municipalities, but at that time it was determined Birmingham didn't have enough. I see that it's increased, but when the question is, what specific concerns does the commission have about short-term rentals? My biggest concern would be identifying them, not only short-term rentals, but rentals in general. Being for the city to be aware, it's fine for conscientious landlords who apply to the city and to who let us know. But I think there are many who don't let us know, especially with short-term rentals. So that, to me, would be one of the big concerns.
Thank you, Commissioner. Bruce, go ahead.
Yeah, I could speak a little bit to that. Staff, Heather Tolliver within the building department has become knowledgeable in searching the short-term rentals, because sometimes, like, you could have some pop up and then they're not there one day, but then they're there the next. And we are monitoring that. We're getting the addresses so we could start tracking them that way and becoming aware of those. For the other rentals, we work with one of the real estate people that we know. I don't want to mention his name, but then he does send us a list every month for properties that are advertised for rent or lease in the city. And staff goes through that list, and then we notify the ones that aren't currently registered. So we are checking that and monitoring that in some ways.
And if I can chime in too, please, Bruce. And the important part too for us is any time that we are looking at any sort of regulation, inspections, what's important, and you're right, Commissioner Hoff, this was really a hot topic a couple of years ago, which is why we have some really great guidance from our Supreme Court, that anything we do, we must do in an unbiased way, meaning that short-term and long-term are treated the same. So if we are going to want to bone up, if you will, on discovering who's renting without us being aware, we need to have that same sort of due diligence towards long-term rentals as well. As long as we are treating them the same, we're in good shape. If we start to differentiate and we start to almost penalize short-term rental properties, that's where we can get into some trouble.
But I have a follow-up question on that.
Go ahead, Commissioner Hopkins.
Since this came up a few years ago, and many of the staff members are aware of this, has anything been done to get the short-term rentals in Birmingham registered? Has there been follow-up?
I think Bruce can jump in on this as well, but I don't think that we've had that many, Commissioner Hopp. I mean, when first, Bruce and I have been asked the question, have either of us had complaints from people about specific properties that turned out to be short-term rentals? And I believe the answer is no, we have not. So the need to follow up or look for short-term rentals, I don't think has been there. We have, and I say we because having been the prosecutor for 20-something years, working closely with Bruce on this, every rental property that has a complaint is immediately looked at, investigated, and if there's violations, violation notices are given, opportunities to cure, and if not, then there have been tickets given and they have been dealt with at the 48th District Court. So have people went to look for the short-term rental specifically? No, because I don't think that there's been a problem. Would you agree with that, Bruce?
I agree with that. I think a couple of years ago when this came up and it was being discussed, we looked at the sites, tracked down properties that were being advertised there. I think back then there was one on the cover of the Birmingham-centric newspaper too. And so that was an easy one to find where that location was at. And I think those were addressed. And then one was in a detached garage. That one had to be taken out because only the owners that live there full time can use the habitable space in a detached garage. And now that, I mean, we will continue to monitor that. I mean, it is fairly new. A couple of years ago, there were not that many. And then the 4 that maybe are registered were some of those. With the 27 that we've become aware of, it looks like 4 to 6 might be registered right now, but there's some additional addresses we need to find. And once we have those addresses, we'll be sending notices to those property owners.
Okay, other commissioners? Commissioner Baller, please unmute yourself and go ahead with your comment.
Thank you for being attentive to my mutedness, Mayor.
You got it. Let's focus, if we can, on the concern that you have about short-term rentals.
I don't have tons of concerns. I think that I'm going to just, not answer these questions specifically, or I may answer a different question than the first question. I think probably some of the people who are doing short-term rentals don't know that they should be registered, and that we could use our communications facilities, social media, etc., newsletters to tell people that if you're going to short-term rent, you need to register. I note that Mr. Johnson said that the most common complaint is about the transient nature. Did I hear you correctly, Mr. Johnson?
Yes, you did. And I would say I may call it a complaint. It's almost like a concern, the transient nature.
Yeah, and I don't know how you address that. I once had some short-term rentals in my career as a second homeowner, and my neighbors had the same complaints. And these were, I was renting to CEOs and college professors and fine, upstanding people. And, I think part of, and I don't know if there's anything we can do about it, but, if you could persuade if we could address that concern somehow, and I don't know how you do it, but I think that there's this fear of strangers, right, that the neighbors have, and maybe it's just, I don't know, maybe we brainstorm it. That's why we're in a workshop, and that's why we're talking about it. I don't know how you do it, but I'd sure like to address this fear that people have of strangers and transients. I see the city manager raising his hand.
Go ahead, Tom.
I just want to comment. I think that gets to the issue of whether this is a commercial activity or truly just another residential activity. And, that's the nature of businesses that do rent to itinerant, interim kind of individuals on short-term basis. That's the nature of it. It's commercial. It would be considered hotel, motel, something like that. But some of these bills propose to not call this commercial and allow it in residential areas, and somehow want to argue that it's all the same. And apparently the courts, according to Mary, have kind of indicated that as well. I can tell you that causes real consternation. And the other issue is, my understanding is, some of these corporations that are in the commercial aspects of rental are buying up some properties, prominent properties, and turning them, using them for B&Bs or short-term rentals as well. So there's some commercial aspects to it, despite what the law says or the courts have said. And I think that's the distinction that you get in our neighborhoods when they consider it STR in their neighborhoods. And I get that. It's like when our college kids come home, right? It's kind of different. They've been out and about, and they come back and they act a little differently than what they traditionally did when they were part of our household. So, pretty much college town experience. Commissioner
Host, go ahead with your comment, please.
First off, I want to ask Mary, I think you have said that it's against the law that we disallow short-term rentals. Is that correct?
That is correct. We cannot ban short-term rentals.
Okay. Can a homeowner association ban them?
We have no control or anything with homeowners associations at all. that we would not be appropriate to even speak about homeowner associations. We have no jurisdiction, no affiliation with homeowner associations.
Well, I'm thinking of Judson Bradway, just to our west. They have a bunch of covenants in their deeds that cover lots of things. Is it possible that a Birmingham homeowner association could ban them?
Again, Commissioner Host, I can't speak to what homeowner associations can and cannot do. Homeowner associations can have very strong, as you just said, covenants, deed restrictions, etc. And if a person violates a homeowner association rule, they would then come to charge of the homeowner association board. The city would never be involved in that.
Mr. Marcus.
So could they do that? I suppose.
Go ahead, Mr. Marcus.
Yeah, for the public's edification, I think it's important to note that we have varying forms of homeowner associations here in the community. Typically, when a project is built, they will have created a homeowners association, usually for condo, townhouse types development. But then we also have what we call HOAs they're not laden with covenants and restrictions in a lot of the single family neighborhoods. That's an invention that came a bit after a lot of our subdivisions were built. So just so that people don't misunderstand that our homeowners associations are all alike and that they can all create these restrictions, that would not be the case.
Okay, the reason
any other commissioner comment, concern? Commissioner Host, go ahead. You can continue.
In looking at, Mary, this is for Mary again. You said you looked at cities that have short-term rental agreements, and you're saying how we can't discriminate between long-term or short-term. What were the municipalities you looked at, and you indicated that they were all similar to us, at least in our ordinances. What cities?
I looked at the city of Ferndale, as suggested by, I think it was Mr. Reagan once upon a time. The village of Lake Orion, which is a short-term ordinance that I personally wrote. I've looked at the cities of Ann Arbor. I looked to our northern communities that have a lot of short-term rentals, such as Traverse City, Harbor Springs, Petoskey, and the meat of all of them is in the ability to inspect and ensure that they're all following the proper codes. And then more than that, to make sure that there's regulations that keep these particular units from becoming nuisances to their neighbors, which is the challenge. They all have, and I should mention, not just our rental ordinance, but our general ordinances all speak to the different regulations that the city can have, which is similar to what is in many short-term regulations. The ability to regulate traffic, how many parking spaces, noise levels, garbage, debris, disorderly conduct, disorderly behavior. So we have in our arsenal all of our general ordinances available to us to do our very best to make sure rentals are not nuisances to their neighbors. So we have everything in our arsenal that we need. And in fact, so many of these communities, including the one I mentioned that wrote these short-term rental regulation type zoning and general ordinances, if this legislation goes through, we'll have to go back and redo most of their ordinances because they are going to regulate behaviors that are not going to be allowed under the new laws.
Okay, where I was headed, Mary, was in the city of Ferndale's short-term rental agreements. They are very difficult on the homeowners if they don't comply. And it starts out as a misdemeanor, but it's punishable by a fine not to exceed $500 or imprisonment for a term of 90 days. Do we have such teeth in our ordinance?
In our general ordinances are, most of them are criminal misdemeanors unless they're denoted as civil infractions. Also, if you are in violation of the different international building codes, electric code, plumbing code, those are all misdemeanors as well. I think our initial ordinance violation, I'm looking at it right now, can be a misdemeanor, particularly when it depends upon which ordinance that they are violating.
Yeah, but is the punishable aspect as heavy as Ferndale has attempted to do?
Do I believe we have enough teeth? The answer is yes.
Okay.
The answer is yes. And again, Commissioner Host, in all of these years, I can say I've never seen a short-term rental come before me as the prosecutor, and it's probably a handful of times our rental ordinance was violated to the point that we had to give a misdemeanor ticket. If there was a violation, the homeowner was notified and would work with the building department to correct. Now, our goal is always one of correction and to get the person in compliance. The whole purpose of these ordinances is health, safety, and welfare. So it behooves us to work with the homeowner to get compliance because that keeps everybody healthy and safe. And that's the goal of these ordinances, not to be punitive, but to keep our citizens safe.
Commissioner Baller, go ahead with your comment. Mr. Marcus, I'll come to you.
Okay, I was just going to say, I think we're all clear on this. I hope we are. And you can set me straight if I'm wrong, Mary. But for the edification of those who might be watching. Short-term rental of accessory dwelling units is not allowed under any circumstances. Is that correct? If you have an apartment above your garage, you are not allowed to rent it out. That would turn it into a multifamily in a single-family zone, and we don't allow that. Is that correct?
That's correct.
Would you want to say something?
And that's a zoning provision, correct, Bruce?
Yes.
Yeah.
Let me, if I may follow up. These Airbnb circumstances where someone rents out a room in their home rather than the entire home, is that in effect a violation of the single family zone?
It may not be. By right, in all of the residential districts, including the multifamily, you're allowed to have up to one or up to two renters or boarders by right. So you could have up to two boarders renting out a room or renting out a room in your home, and that would not be required to be licensed as a registered rental. That's a right by the zoning ordinance.
So then I'm confused then. That seems to conflict with the notion that you could not rent an accessory dwelling unit. An accessory dwelling unit is a room in your home, is it?
The accessory dwelling unit is not a room in your home. I mean, it is in the accessory structures for the dwelling unit specific that it's only to be occupied by somebody that has their main living quarters in the house.
So it is the detached nature of it that causes it to not be part of the exception you noted earlier, that you can rent out a room or board someone. That assumes that it's in the main dwelling.
Correct. And that person would be able to utilize, say, the garage for purposes, but they got to have a main living space in the house.
It kind of goes back to the historical references in zoning ordinances that only allow one principal residential unit per lot of record. And that's not just our zoning ordinance, that's others. And so I think what happens is, even in an accessory structure, it creates a separate dwelling unit, which then it, becomes kind of that zoning conflict with only one dwelling unit, principal dwelling unit per lot of record. Bruce, I had a comment though, as we continue this conversation. Of the known STRs that we have, are any of them currently, do they have the rental license that we do have?
There are 4 for sure that have the rental license, and there are 4 that we're looking into. They're in a multi-family building, and we don't know their exact address.
Yeah. So I think one of the things that will come out of this meeting, just from an administrative standpoint, is we will contact those that we can identify by various methods of identification and let them know that we've identified them as an STR and they would be required to get a rental license in the city of Birmingham going forward if they're going to continue to do that. Right, Bruce?
Yes.
Okay.
Okay.
And if there could be one other thing out of this meeting, if you've not had the opportunity to speak to your representatives and encourage them to take a better look at the language of these proposed bills, they would really strip municipalities' rights to regulate all rentals and perhaps even take away our licensing ability. That I don't think is going to happen, but we can't be certain. So please reach out. The MML has a really good blog that gives information about this and who to contact and how to contact them. So if you haven't done that yet, please do so.
So, Mary, if you don't mind mute me down. Here we go. So, just looking at, first, I appreciate the wonderful presentation, Bruce, you had done, and really the understanding the laws and regulations that we had in place already, and also that things are changing ahead of us. Just listening to majority of the concern, I really don't see any major concern that Birmingham is facing today. From our prosecutor, 20 plus years, that had mentioned that I can barely remember of one misdemeanor that I gave. That's really comforting to this. I'll speak for the city of Birmingham. Now, the concern, I just want to follow the discussion questions as they come 1, 2, 3 in front of me. Several commissioners had mentioned to identify the properties. It seems like we're already ahead. Mr. Johnson had gave us a map identifying every rental property, even to the teeth, where what type of rental property. Also encouraging registration. This is something we can do so much to control, but some tenants that they act ignorant, as they don't know that they need to register or get a license, but that we can push education as much as we can. But this is a responsibility on any tenant to understand what is he getting himself into when he was renting anything, whether it's a single family or it's a condo. On the second one, what additional regulations we have, it seems from what I understood myself from our attorney here, that really we are very, very, we have a great and strong ordinance that maybe barely we can touch to change anything in it. And the advantage and disadvantage of this, nothing is perfect. I can only call one advantage that it brought to my attention by speaking to really one of the reputable real estate and brokers in our community. That if a seller of a home, let's say I'm selling my home and I want to close June 30th, we have to really be very careful on how we do this. But again, there's nothing we're doing tonight anyhow. But in a sense, if I close on June 30th, my house, I closing on it, I'm selling the house. Well, I still need another 30 days myself after the closing to really have to stay in my house, but I become a tenant myself to the new buyer. And that fits in all these new rental state legislation that have been changing. So we have to be very careful how it affect the industry overall. And with that, Mary, I have a question for you. Just saying the summary of what I just learned is whatever happened on the state level right now. And if we don't have any issue in Birmingham, as I haven't heard from any commissioner yet. We have 10 more minutes left on the conversation. That we have the regulation, we have the ordinance, we're doing everything right. How is that going to affect us if we're okay with where we are? Is it going to be upper hand that going to tell us to do different things as what we're doing today?
And so the two bills that were before the House and Senate did not pass. There was substituted language that was given back, and it's gone back to committee to continue to discuss this. Some of the language in the amended substituted bill would make it so that we maybe couldn't get permits and licenses for our rentals at all, let alone short terms. So we do not want that to happen. We still want to be able to have a permitting and licensing process. That said, Mayor, if you recall, the beginning of the language of these two bills say for the purposes of zoning.
Correct.
Our ordinance is not in a zoning ordinance, it's in the general ordinance. My concern, though, however, is if the zoning ordinance says that you cannot license and permit, could someone challenge us if we are still doing the permit and licensing? So probably every community in Michigan would hate to see that language in this new bill. I also think, too, that it doesn't allow us to ever have any say in where these rentals are. So let's say something changes in the city of Birmingham and all of a sudden we become a hot destination, maybe, who knows, we open up a university. Right now, the way it's written, we could not regulate where in the city these rentals are. They could be anywhere. The short-term rentals could be anywhere in the city. Now, that probably doesn't affect us today, but one never knows the future. And anytime the state is taking away all of the legislative powers of the commission, that's not a good thing. We should have the ability, as we do under the Home Rule Act, to have self-governance in a lot of areas, and particularly about our zoning and about how our communities are developed. So the language of this bill just goes too far. It takes away all the power of municipalities, and that's never a good thing, in my humble legal opinion.
Well, let's hope for the best. I appreciate the clear explanation, Ms. Kacharik. With that, I'm going to leave the last few minutes for public comments. If we have public with us, please, this is the time to address any or make any comments on our discussion tonight. Would any of the public would like to make a comment? Eric, help me. Am I missing anybody?
You have 4. Mr. Burns is the first.
Oh, sorry. It's not showing on my screen at all. Let me see. Mr. Burns, you said?
Jack Burns.
Mr. Jack Burns, go ahead. Eric, for some reason, I don't see the hands risen on these people. But go ahead. I apologize. Go ahead, Mr. Burns, with your comment, please. Oh, there we go. Now I see them.
Can you hear me?
Yes, go ahead.
First of all, I'd like to congratulate the entire city team on how on top of this entire situation you appear to be. There's one thing I would like to clarify, and I'll explain why. I'm assuming that there's no difference in the way we approach a short-term lease or a short-term rental versus a long-term rental versus a lease. There's no difference in the way we approach it. The reason I'm asking is we live on Putney Street, which is only 8 houses, okay? The house next door to us recently sold just before Easter to a gentleman, and he put a lot of money in upgrading this house. Now he's got a sign out front that says basically it's not for sale, it's for lease. So he's going to lease this home to obviously someone on a short-term, long-term, or maybe longer basis. I'm just assuming all the recourses and all the ordinances we've spoke about tonight, and again, I congratulate you on how thorough it seems to be, they all apply to him, right?
I can answer that.
Go
Thank you.
ahead, Mr. Johnson.
You did an outstanding job, as does Ms. Kucherick. Thank you.
That would be applicable to the situation you're describing.
Very good. You've answered my question, and again, congratulations.
Thank you, Mr. Burns, for your comment and question. We'll go to Mr. Bloom. Please, you have 3 minutes, and Mr. Hague, 3 minutes, because we have 6 minutes left on the meeting.
Hi, I want to reference Mary's comment about if the state passes this, that it would be taking away our rights. Do we have any recourse either before the state does this or after to argue against what the state's done through legal action or attempting to do?
Would you like me to respond, Mr. Mayor?
Go ahead, Ms. Kucherick, you can answer.
Thank you. I wasn't sure what you meant by the term recourse.
I basically what I meant is can we sue the state and say you're taking away our rights without due process or without?
I can't answer that, Mr. Bloom, because it would be dependent upon the facts and circumstance that would make a case rise to that level or become ripe. So the best advice I can give you, because I can't answer that question, but what I can say is that your voice at the beginning is where is helpful and appropriate. So if you disagree with this legislation, then reach out, please, to your representatives and let them know what you think and believe about it, and let that happen before it goes to the Senate and House floors for votes.
Okay, is there anything that the city can do more than is being done now to make those voices heard?
I believe that the city has been reaching out and going to the blog from the MML and making their voices heard.
Okay, thank you.
Thank you, Mr. Bloom, for your comment. Mr. Hague, go ahead, please, with your comment.
Thank you, Mr. Mayor. Keep it brief. Mr. Bloom touched on one of the things I wanted to touch on. Maybe, Ms. Kucherick, if there was something can be added to the minutes for where we can access anything for specifics for where we could send letters, emails, whatever it may be, to lodge our complaints against the proposed legislation, that would be very helpful. The second part, actually, I would like to ask, and it's probably open-ended. In the package that's provided, page 14 is just a convenient one, 14 through 15, where it goes through the wording of the people of the state of Michigan enact blah, blah, blah. It's actually the beginning of page 15 where it says, is not a commercial use of property. And I know it was touched on earlier, but I don't fully understand, and you may have to come back on this because of time. But is it the earning of money via property, is that not by definition a commercial use, whether it's under an LLC, a corporation, an individual, whatever it may be? Is that the loophole that we can exploit? And like I said, we may have to come back to that because of time. Thank you.
Yeah, Mary, you don't have to answer that in a sense unless you can give them a quick 2 seconds. Is it a long dialogue? Then we'll leave it to long.
No, it's not, Mr. Mayor. Mr. Marcus already said it. Of course, it's commercial in nature. Unfortunately, that's not what our legislature is saying, and that is what the court is not saying. I don't get it either. Logically, it's commercial to me. I think it's commercial to all of us. Unfortunately, we're not the ones saying that it's not commercial.
Okay, thank you. Thank you, public. Thank you, commissioners. Mr. Marcus, would you add anything before I adjourn the meeting and go to my next meeting?
Just one thing. I would say that when you look at the legislation that's being proposed, it's easy to say that it's trying to, one size fits all kind of issues. And I would point out to you that there are several hundred communities in the state of Michigan, and they all have different characteristics, and some need this need regulation, and some not so much regulation. It depends on the character of the community. So one size fits all, which tends to be the way the state has to address things so that it's equivalent or equal across the state, really doesn't suit the individual characteristics of the community that the state has in it, and is a disservice, in my opinion, to treat it that way and not respect the home rule rights of the individual community.
Thank you, Mr. Marcus. With that, I just have to say it's a very productive, very informative work session meeting that we just had. Thank you, Bruce and Mary and Tom for a wonderful preparation. It really was very informative. With that, I'd like to adjourn our meeting for the City Commission. I'm sorry, the workshop session, and we have to start our regular meeting in 1 minute. Commissioner, take your break, and we'll come back. Meeting adjourned.
Got a 1 minute break before the next meeting starts.
Recording stopped. Recording in progress.
Okay, Eric, ready to take off here. I think majority commissioners are back. Let's see. Yep. We're all back. Can you hear me, Alex? We're good?
Yep.
Awesome. Eric, can you hear me?
Yes, we're set.
Give me the thumbs up when you let everybody in, and I'm ready to kick off the meeting.
Hey, everyone's already in.
Awesome. Thank you so much. Good evening, everyone. I'd like to call the Birmingham City Commission of June 14, 2021 to order. Could you please join me in standing for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Will the clerk please call the roll?
Mayor Boutros,
Here in Birmingham, Michigan.
Mayor Pro Tem Long,
Here in Birmingham, Michigan.
Commissioner Baylor,
Here in Birmingham, Michigan.
Commissioner Hoff,
Here in Birmingham, Michigan.
Commissioner Host,
Here in Birmingham, Michigan.
Commissioner Nikita,
Unmute yourself, Commissioner Nikita, please, for the record, and go ahead with your
Here in Birmingham, Michigan.
yes.
Commissioner Sherman,
Here, Birmingham, Michigan.
Thanks, Alex. With that, we go to proclamations, congratulatory resolutions, awards, appointments, resignation and confirmations, administration of oath, introduction of guests, and announcement. We do have a important announcement and a wonderful announcement for the Common Ground Proclamation, and congratulations to Common Ground in celebrating 50 years of providing 24-hour crisis services dedicated to helping youth, adults, family in crisis, and they reach more than 80,000 people each year. There is a proclamation in the agenda and ready for the public, and actually was presented by one of our fellow commissioner, Commissioner Hoff, in their celebration last week in person. But now I'd like just to read the last sentence of it, where I, therefore, be it resolved that I, Pierre Boutros, Mayor of the City of Birmingham, extend my congratulations on behalf of the Birmingham City Commission and the residents of Birmingham to Common Ground for 50 years of invaluable contribution to the community by helping youth, adults, and family in crisis. And I'd like also to acknowledge that we have, I think, on Zoom with us, I see his name, Mr. Jeffrey Kapuscinski. I hope I did not call your last name, but he's the Chief External Relationship Officer. Mr. Kapuscinski, I'll let you say a few words if you'd like to. And I want to thank you personally on behalf of the City Commission and the residents of Birmingham for all you do. The floor is yours.
Well, thank you, Mr. Mayor. And for the record, you pronounced my name just perfectly. Birmingham is a very special place, obviously, for Common Ground. For those of you that don't know, we got our start in Birmingham 50 years ago when a group of concerned parents and youth came together concerned about the rise in teen suicide and substance use. So you date all the way back with us, the community of Birmingham, and that relationship continues today, and dare I say, a partnership today as we continue to move forward, helping people move from crisis to hope, and celebrating each fall with the Art in the Park festival that you all allow us to put on in your fair city. So on behalf of all of my colleagues at Common Ground, I just want to say thank you again. This is an incredible honor, and we are very, very grateful to the Commission and the people of the great city of Birmingham. Thank you.
Thanks again. And congratulations again, and thank you for all you do. Many years to come. With that, we go to our second item on the agenda. It is open to the public for matters not on the agenda. Public, any comments you might have for matters not on our agenda tonight, please raise your hand so I can identify you, and the floor would be yours. I do not see any hands. Eric, help me for last call here.
I am raising my hand. Mrs. Acioli,
Go ahead, Ms. Ascioli. I don't see your hand raised, but go ahead. Please state your full name for the record, and please speak for matters not on the agenda tonight, but go ahead.
My name is Roseanne Ascioli. I moved to Birmingham when I was a fourth grader back in 1966. I have been living in the same home on Bauer Street for the last 21 years. And I am here today to bring some information to you about what myself and many residents are really dealing with on a daily basis in our neighborhoods. And I just want to give you some perspective from sort of on the ground experience. My issue really concerns the current state of walkers' rights in the city of Birmingham, specifically regarding the dogs that are on neighborhood streets. And I have reviewed Chapter 18 in the Code of Ordinances prior to this meeting, and I've looked at it on several occasions before. And I just want to highlight for you some of the things that many of us residents are coping with on a daily basis. I recognize that the city is not liable for any kind of individual kind of behavior from any dog that might come in contact with a resident when they're walking. But the reason I'm bringing this to the commission's attention is that I feel that the community's commission has a responsibility to make sure that the education of both residents and people who enter the city, because it is called a walkable community, are aware of what the expectations are in the city of Birmingham. What prompted me to do this is I want to highlight for you some of the incidents that have occurred to me specifically in the last 3 weeks. 2.5 weeks ago, I was walking my dog, who happens to be an 8-pounder, and I have owned dogs my whole life. I'm a dog lover. We were walking down Eaton, and out of the clear blue, a French bulldog raced across traffic. It attacked my dog. It attacked me. It had license plates on it. I sustained a pretty severe injury to my elbow, as well as a gaping wound. After leaving my area, and luckily a motorist stopped to help me, and another man from some location heard me screaming and came to my assistance, the dog ran over to Griffin Claw. When I got home, I walked back 2 blocks and I made a police report where pictures were taken of my wound. But as the policeman was in my home, he heard over the radio that that very same dog was over at Griffin Claw bothering people who were trying to eat dinner outside. Another incident was that I was walking my dog and a house that was under construction was in view. All of a sudden, a pit bull attempting to be controlled by a 12-year-old who was probably only about maybe 25 pounds heavier than the dog itself. The boy lost control. I had to run into the house that was under construction, and the carpenter who was working in the home had to assist the boy to get control over the dog. There were no parents around. Another thing that happened in the last 2 weeks is I've had 2 incidences where owners have been sitting on their porch or their lawn, dogs not being leashed or held onto, and dogs have jumped off the porch and run off the lawn and have lunged toward myself and my dog. And I have repeatedly recognized that as I'm walking, I literally have to look for safe places to go because people are not able to control their dogs, and they're unaware of a lot of the expectations the city has in relation to this. Now, a lot of people, when you look at the Code of Ordinances, it identifies dogs as being vicious, but it really doesn't define it behaviorally. Like, what is a vicious dog? Most people think that that only means a bite, but quite frankly, the 7-inch scar that I will have on my elbow was not a bite, but it was in fact a bona fide injury that I'm going to have to live with. Now, the thing about it is that I have, since these incidents have been occurring, I've talked to many neighbors and other walkers, and I walk every single day 2 miles in Birmingham, rain or shine, no matter what the season is. So you are talking to an experienced walker. And many residents have said to me they routinely are fearing for their safety as they walk in the neighborhoods because people are not controlling their dogs. And just on Friday, there was an article in the Detroit Free Press by Nancy Kaffer, and she's one of the columnists, and it was talking about that very fact, that particularly since the pandemic, when so many people have gotten dogs, that they have not spent the time to socialize them or to really learn how to train them when they're walking on neighborhoods around other people or around other dogs. There's a man that routinely walks in my neighborhood who has a large dog, and the dog is not on a leash. And when I gently attempted to confront him, he said, "My dog is friendly." But animal behaviorists and researchers will tell you that human beings far underestimate the dog behavior, the innate behaviors that are part of being a creature.
I deeply apologize for your incident myself. Your comment well taken. We appreciate your time coming and telling us.
Let me just end then with two things. All I'm asking is that on a yearly basis, the city commission uses the bulletin to at least remind residents about what taking care of dogs is about. And also, many other cities have adopted identifying a walker's rights list that protects walkers and gives them the sort of background on what to do when they have these incidents happening. So I just feel like the city, who is very proud of being a walkable community, is somewhat negligent in recognizing that walkers are not really very safe.
Thank you, Ms. Ascioli, and just want to let you know we take your comments very seriously. We appreciate your time. Thank you, and sorry about your incident. Any other public comment on matters not on the agenda? Seeing none, we move on to our consent agenda. All items listed on the consent agenda are considered to be routine and will be enacted by one motion and approved by a roll call vote. There'll be no separate discussion of the items unless a commissioner or citizen so requests, in which event the item will be removed from the general order of business and considered under the last item of new business. Commissioners, any item to be removed from the consent agenda? Commissioner Sherman?
Item H, please.
H. Sherman? Commissioner Hoff, did I see your hand?
Yes.
Go ahead.
Item E and F.
E and F. Okay. Any other items would like to be removed by any other commissioner? Seeing none, I'll entertain a motion, please. By the public, any by the public? Seeing none, I'll entertain a motion. Commissioner Sherman, go ahead with your motion, please.
I'll move the consent agenda excluding items E, F, and H.
Second.
Seconded by Commissioner Nikita. Will the clerk call the roll, please?
Mr. Sherman?
Yes.
Commissioner Nikita?
Yes.
Mayor Pro Tem Long?
Yes.
Commissioner Baylor?
Yes.
Commissioner Hoff?
Yes.
Commissioner Host?
Yes.
Mayor Boutros?
Yes. Thanks, Alex. We'll start with Commissioner Sherman. Item H.
I pulled this because this is now either the second or third change to the ice arena project. And I just want to know how many more of these change orders and additional items we're going to see for the ice arena. One of the concerns that was expressed when the original proposal came forward was that we weren't ready for this, that there were a lot of issues that were left open. And it seems like that was a pretty accurate commentary.
Ms. Wood, would you like to answer that?
Sure. Yes, Commissioner. Good evening, Mayor, Commissioners. Yes, Commissioner Sherman, this item is what was anticipated when the City Commission approved the contract for the general contractor to Gleason. There was also listed a contingency dollar amount of approximately $400,000 and soft costs of about $515,000. And as part of that report, we did identify that there were going to be some other services, such as the one you see before you this evening, technology and audio video. And that being because we had to bid that out. That's a project that's not incorporated into the general contractor services. In fact, the city wanted to have their hands on that and a little bit more control over a lot of the consultants and services. So this would be the last one. This is the last engagement of the soft cost portion for the ice arena, but it was certainly anticipated.
I think
This is it? We're not going to see any more?
Mr. Marcus is want to add something to it too.
But go ahead.
Lauren, maybe you should discuss what we discussed today regarding Detroit Edison and the pole that we own and the upgrade to that as well. Isn't that part of the ice arena project too?
Yes, Tom, it is. So right now we're in the midst, we have Robert Stempian with Plant Moran Cressa, who is our owner representative. And just in the last few weeks, we've been the Department of Public Services, and we incorporated our building department, internal, and our engineering department. DTE approached us with regard to the primary electric that goes to that services the ice arena. The city actually owns the primary and is responsible for the primary setup and connection from the pole or post that's on Lincoln Road and into the ice arena. We are the primary, considered a primary service contract. We are responsible for that line, and we're also responsible for the transformer which sits on site. And they brought to our attention that because they put a new pole in recently, you notice a lot of the work they've been doing on Lincoln and South Eaton, they did put a pole on the west side of the existing pole, and that's going to require the city to redo that entire line. It does not reach that new pole. The primary service has a conduit that goes beneath from that pole into the arena or to the electric transformer. To service it, and it also is the original electric line that goes into the arena, which of course 1972. So we did get pricing for that. I'm assembling a report for Tom of the various change orders. We've had credits and adds to the considered change orders, if you will, as we've gone forward, but they've always been to our favor, the city's favor. We've done value engineering throughout the start of this project too. But with this, Tom and I have been chatting about it, but we found a price out last Friday, approximately, I don't have it right in front of me, but about $74,000 or $75,000. It will add to this project for Gleason to oversee it. Gleason hired a contractor, and that'll have to occur.
Thank you, Ms. Wood. Mr. Marcus, go ahead with your comment.
Yeah. Part of our review, Commissioner, in bringing this up is because you asked a fairly open question about what else do you see coming. Mm-hmm. So I felt we better tell you that. Part of my review will be to determine if there's anything as to a cause and effect and whether the actions of DTE caused some of the improvement costs that they're trying to pass on to us. Otherwise, it's clearly an obligation we have as a private line, but if they changed it for some other reason, I need to find that out so that that gets played into the negotiation. We haven't done that yet. It was just brought to my attention today. So that's part of the equation as well.
Thank you, Tom. Commissioner Hoff, I see your hand.
Yes, I have a,
Commissioner Hoff,
yes. I have a question about this as well. When I saw this, I wondered why we're being billed $45,000 for lighting and sound. Wasn't this a line item in the a proposal that was approved by the commission? And if not, why wouldn't it be? I mean, you're planning on the ice, the bleachers, the stands. You would plan on the lighting and sound. So was it a line item? And if it wasn't, why not?
Go ahead, Ms. Wood.
Thank you. No, Commissioner Hoff, it purposely was not a line item because Gleason doesn't do that kind of work. Their subs wouldn't do that kind of work. And it's audio, video, and a public speaker system. And so that's on the onus of the city or the owner to add that to the arena. And while it's being under construction, this is the best time to put that new system in.
Go ahead, Mr. Marcus.
And typically, Commissioner, you do separate some of these items out so that you don't get charged the overhead of a general, when in fact we can solicit that information and those costs on our own. And sometimes we'll pick different parts of a project and remove them from the general, who doesn't have the experience in those specialties anyway and doesn't then get the overhead administrative charge against that particular item in the contract.
Well, that makes sense. Your explanation makes sense. My only comment would be, it would be helpful when we approve something like $5 million, that we know it might be $5,300,000 or something like that for additional expenses.
It's my understanding that some of these extraneous costs were rolled into that overall bid amount or total amount when we were estimating. Isn't that the case, Lauren?
Yes, Mr. Marcus, it was.
Oh, so the total amount that we approved includes these figures?
Not in the general award bid, but in the estimates that we used for the total cost of this project.
Okay.
I'm not sure that DTE poll did, though.
Right.
Okay, Commissioner Baller.
So just to be clear, what I'm hearing the administration telling us is that these are not extras. These are not over and above what we approved in terms of the estimated total cost. I want to make that clear. Right? Correct? Am I correct?
Correct.
Thank you.
Okay, any other question? Commissioner Nikita?
Yeah, so just getting back to the 75,000 that's estimated for the DTE. That's additional. That's beyond anything we had established because we didn't know about that, or it's additional. It's an additional cost. Is that correct?
Yeah, that's a fair.
That's
okay.
Yes, that's separate. That was an unforeseen condition. Yes.
Right. Okay. So that 75,000 is above the amount we had identified. The other question is, where does that 75,000 come out of then? Would that come, or whatever the number is? I understand it's not confirmed, but we're guesstimating at this point. Would that come out of the parks bond? Will that come out of our general fund?
That'll come out of the bond proceeds. If you recall, we sold at a premium. As a result, there was we took advantage of that, and there is more funding available for that. For the bond issue over what was anticipated, which means you'll probably reduce the second issue later on, which we estimated will probably have a higher interest cost for those bonds. But yes, this is a legitimate and expected bond proceed expense.
Okay, thank you.
Mayor Pro Tem Long, go ahead.
And one more clarification, please. So City Manager Marcus, part of your investigation is going to be why DTE installed the new pole and whether this is something they would have done anyway or whether it's directly resultant from the construction project?
That is correct.
Thank you.
I think those are fair questions that need to be resolved before we submit to the City Commission. Again, this was just brought to my attention today. And so as I think it through, part of my questions went to why was it being moved? And if it's being moved, which causes a shortening of the available line to reach our facilities, why then is that our cost? But I'm sure we'll have a discussion with DTE. I have found their community rep to be very good to work with, and she's been very helpful in addressing a lot of community complaints that we've received. Very efficient the way she deals with things. So I trust we'll get the answers.
Thank you.
Thank you, Mr. Marcus. With that, Commissioner Sherman, any other questions?
No other questions. I'll move the suggested resolution.
Second.
Second, Commissioner Host. Any public comment on the motion? See none? Will the clerk please call the roll on item H?
Mr. Sherman?
Yes.
Commissioner Host?
Yes.
Commissioner Baylor?
Yes.
Commissioner Hoff?
Yes.
Commissioner Nikita?
Yes.
Mayor Pro Tem Long?
Yes.
Mayor Boutros?
Yes. Thanks, Alex. We'll go to item E, pulled by Commissioner Hoff. Commissioner Hoff, the floor is yours. Item E.
This item is for Eric Bronk, and this has to do with the internet connections to the parking structures. I see that it is recommended the company Crown Castle, and yet as I looked over the materials, I see that ClearNet has been our provider in the past, and that their bid is less than Crown Castle. And I wonder if we can have an explanation of why we're going with the one that's a little more and what the equipment is. Is there a difference in equipment?
There is a difference in connectivity. The Crown Castle connection is a 100 meg line to each garage. I requested the same thing from ClearRate, but the proposal they gave me was a 100 meg line from each building, which means I only have 100 meg coming into City Hall for 5 garages or parking structures. I can show you the Crown Castle plan if you'd like to see that again to get sort of an idea of what we're looking at. But that's the main reason that we're going with Crown Castle. The secondary reason would be that I would like to get everything under one umbrella as far as a vendor who's handling all of our connectivity. And Crown Castle is our vendor that handles all of our internet connection. They also have other abilities, which right now we're not working with, but we may use them in the future for other projects.
Okay, thank you. I don't have to see anything further. If you feel that this, it's more advantageous to use Crown Castle, then I'll move the suggested resolution.
Second.
Seconded by Mayor Pro Tem Lund. Any comment on the motion by the commissioners? See none. By the public? Seeing none, bring it back. Alex, would you please call the roll?
Commissioner Hoff?
Yes.
Mayor Pro Tem Long?
Yes.
Commissioner Host?
Yes.
Commissioner Nikita?
Yes.
Commissioner Sherman?
Yes.
Commissioner Baylor?
Yes.
Mayor Boutros?
Yes. Thanks, Alex. We move to item F, pulled by Commissioner Hoff. The floor is yours, Commissioner Hoff.
I pulled this because this is the renewal of consultants' agreements. And I think the 3 consulting firms that are listed here are MKSK, Police and Vanderbrink, and OHM Advisors have done a wonderful job for Birmingham, and I'm all in favor of renewing their agreement. But what I don't understand is there an increase in costs for this renewal? And what percentage additional are we paying for these services? Because they do work on several different projects for us. So I asked that question of Jim Surhai.
Sure, Mr. Jim Surhai, good evening. Go ahead.
Thank you, Mr. Mayor. Thank you, Commissioner Hott, for your question. Yeah, I did look into the rate tables from 2018 when these contracts were last signed and compared them to the current proposed rate tables. Just as a quick note, I would expect a reasonable increase over that 3 years to be a total of 10 to 15% or 3 to 5% per year would be kind of the in my terms expected average. And looking at these rate tables, they don't always exactly line up, for personnel classifications. But after doing some digging, and I talked to all 3 of the consultants and got some more information from them, basically the bottom line is for MKSK, the blended, their rate of the personnel that they would use on the project and their classifications, those costs on average are going up 6.9% in total versus 2018. So about 2.3% per year increase. Fleiss and Vanderbrink, after talking to them, their overall cost is going up about 11%, which is 3.7% per year. And the majority of that is because the primary traffic engineer, Julie Kroll, had a promotion. So now she's in a new classification compared to where she was at in 2018. And then for OHM and their numbers, they are going up a total of 8.3%, which works out to be about 2.8% per year.
And do you feel these are reasonable increases?
Yes.
Okay. With that explanation, I'll move the suggested resolution.
Second.
Second by Commissioner Nikita. A public comment from the commissioners on the motion. Comment from the public on the motion. I see Mr. Reagan.
Good evening. Yes, my comment has to do with the renewal of the contract with MKSK. I had the opportunity to speak to them informally at the multimodal boards, I believe it's the last meeting. Question I had at that time and remains is, what type of assurances do we have that the public, that is the residents, will have an adequate opportunity to provide their input to the South Old Woodward design? The reason I ask this is because this is not like phase one, where North Old Woodward, which is largely separate or independent of the residential neighborhoods, South Old Woodward is directly adjacent to them. In fact, I'm less than, you'd have to ask Commissioner Host, but I think I'm less than a 5-iron away from the proposed site. And the discussion at that time was they would speak to the business owners. Nowhere in that discussion was there any mention of speaking to the residents. So my question is this, or my comment is this to the motion. What assurances do we have that they would listen to the residents and then incorporate them into their recommendations? Thank you.
Thank you for your comment, Mr. Reagan.
Mr. Sirhai.
Mr. Sirhai, would you like to answer this question if you don't mind?
Yeah, the services under these contracts for MKSK are as requested services. So, part of that for the South Old Woodward project is a public engagement, effort. And, as we explained at the multimodal board, that was the first step of, rolling these concept plans out. And we fully intend to, not only through the Engage Birmingham platform, but also explore is, doing a public meeting that would give all the residents opportunity to speak and give their input.
Thank you, Mr. Sirhai. With that, any other public comment on the motion? Seeing none, we'll bring it back to Alex for a roll call, please.
Commissioner Hawk?
Yes.
Commissioner Nikita?
Yes.
Commissioner Host?
Yes.
Commissioner Sherman?
Yes.
Mayor Pro Tem Long?
Yes.
Commissioner Baylor?
Yes.
Mayor Boutros?
Yes, thank you, Alex. That concludes our consent agenda. We move to unfinished business. First item under our finished business, we have a public hearing to consider the SLUP final site plan design review at 720 North Old Woodward, which is the Vinewood Kitchen and Cocktails. My understanding, and I have a question for Ms. Kacharik, actually, we did receive a formal notice from the owners of Vinewood that they would like to remove the Vinewood for consideration for this year. My question to you, without going into the details right now, and I don't believe we need to hear from Ms. Ecker unless the commission should want to. Should I open the public hearing first? Or what? Any action? What action am I supposed to go forward when I receive an email few hours before the public hearing.
Yes, there is a public hearing. It has been noticed. So yes, you should open the public hearing. I'll give the explanation you just did, Mr. Mayor, that Vinewood is withdrawing their application at this time. If anyone still wants to speak, you should hear them because, again, it is the public hearing. My guess is no one will speak because it's moot, and then accept a motion to remove this from the agenda. It wouldn't be postponed because we don't have a date certain. We don't want to table it because it might come back someday. So just to remove it from the agenda.
So I'll open the public hearing, then close it, then entertain a motion. All right?
Yes.
I'd like to open the public hearing. As stated earlier, don't need to repeat the explanation. The owner would like to be removed for the consideration for this year. And any discussion on that, commissioners? Or Jenna, any representative from I think Mr. Marcus would like to comment on something. Mr. Marcus, I'll give you the floor.
Jana, I think that the petitioner also asked for a reduction in the fee. And I want to point out that it's my position that we would not offer a reduction in fee. We have spent numerous hours on the review of this, which is included in that cost. Mainly that's included in the cost, plus these meetings that have been continued and this public hearing. So that's my intent unless I hear other direction from the commission. Thank you.
Ms. Ecker, what are we looking for in fees? And don't have to be exact, just roughly. What would that entitle us?
Generally,
Anybody
when an
apply for permits and stuff like that?
applies for a special land use
Oh,
permit.
I'm sorry, I couldn't hear you. I'm sorry, go ahead, Ms. Ecker.
When an applicant applies for a special land use permit and a final site plan review for a bistro like this, the fees are approximately $2,800. The city manager is correct. However, we've certainly expended at least that much in advertisements, public notice, staff review, et cetera. So any new application that would be submitted, I think next year would be a separate matter.
Fair enough, Ms. Ecker. Thank you for clarifying, just for the commission to understand what we're facing to. Commissioner, any further discussion on this? Do we have any, Jenna, any the owner's representative, or they'd like to say anything? Or we're good?
I do not see them, and they indicated that they did not intend to attend tonight.
Okay, with that, then I'd like to close the public hearing. And I think it's time to entertain a motion. Commissioner Sherman.
I'll move to remove this from the agenda.
Second.
Seconded by Commissioner Hall. Any comment on the motion by the commissioners? By the public? Seeing none, will the clerk please call the roll?
Commissioner Sherman?
Yes.
Mr. Hoff?
Yes.
Mr. Nikita?
Yes.
Mayor Pro Tem Long?
Yes.
Commissioner Baylor?
Yes.
Commissioner Host?
Yes.
Mayor Boutros?
Yes. Thanks, Alex. We go to item B under unfinished business. That is in front of us. We have a resolution to approve a scaled down participation in the annual Woodward Dream Cruise event for the year of 2021 in the city of Birmingham due to public health and safety concerns attributed to the COVID-19 pandemic by managing the large crowds that any participation in the Dream Cruise naturally creates. And we do have a complete resolution in our agenda packet. And this time, I think I'll leave the floor to our Fire Chief, Mr. Paul Wells, on continuation of this discussion. Go ahead, Mr. Wells.
Good evening, everyone. Eric, if you can let me share my screen, please.
Sure.
So just a little background on some COVID update. I like to keep everyone updated. Since our last meeting, the United States as a whole did come down on the numbers, but the last 2 weeks, we've had about 8 cities see an uptick in COVID. We are also seeing an uptick across the world in different countries. Moscow today is doing a shutdown. Great Britain is extending its COVID restrictions for another week. The latest on the Delta variant is showing that it's only Moderna and Pfizer vaccines are 79% effective against it, so 1 out of 5 people can still get it. Right now, 10% of the cases in the United States have the Delta variant. They think this fall we're going to see a rise in that, especially with the amount of the population that won't get vaccinated. Currently, the J&J vaccine is about 60% effective against the Delta variant. And then as of right now, those 12 and older in the state of Michigan, there's about 55% of the population is vaccinated, and the vaccination rate is slowing down. So with that being said, there's still concern. There's still the CDC orders and guidelines for both to not have large scale events. And if you do, to provide some social distancing, that kind of thing. So I appreciate you letting me provide a scaled down version since we're still uncertain what the next few months will bring. I listened to the feedback from a few weeks ago, working with the BSD. You have this map here in front of you. This shows 3 of our major vendors in the past. You guys can see the map, I take it? Is that correct?
Yes.
Okay.
Yes.
So this pink area, that would be a site that GM can have for their what they're going to do. They know this is going to be available if we vote on it tonight. We also have the green here on the end. That's going to be for the WOMC radio tower that they do, the radio station. And then this yellow section over here, this is going to be staging for Channel 7 News, and they're going to be using the facility at the Birmingham pub. But they need some area for parking their trucks. And then we can still have vendors, smaller street vendors, food sales, and car shows in this blue section here. Bowers would be open for emergency traffic, for police and fire, along with the end of the event over here on the south. So this is definitely scaled down. You'll still have a large concentration of crowd here, but it'll be much easier to manage with police and fire on the day of the event. Any questions so far?
Thank you, Chief. Go ahead, you may continue with your presentation and I'll leave it open question. Are you done, Chief?
Sure, just one more thing. I did reach out again to asking for more support, fire support at a couple of my county meetings. Again, unfortunately, not all fire chiefs are as involved and have a say, behind the scenes. They're hoping to have a reduced amount of attendance. Just at my chief's meeting I have later on this week, one of the things is just overall summer attendance and summer staffing concerns, because fire and police are down with staffing across the country, as a lot of the workforce has seen some struggles getting good people. And I think we're going to have a busy summer as it is. So I appreciate, again, let me come to you with a scaled down version. I'm ready for any questions at this time.
Yeah, thank you, Chief. Commissioner Hoff, go ahead with your question, please.
Thank you, Chief Wells, for scaling it down, and I think this is a very reasonable compromise. And but I'm a little surprised that you're still allowing the car clubs, because I thought that might be something that would be eliminated. How will it be determined? Because the car clubs usually take up quite a few blocks, a little bit further north on Old Woodward. How will it be determined which car clubs get this space?
So we had some blank space to use, and we gave the BSD, they're the ones that decide every year. They have to turn away car clubs as it is, because when we open up the extra space, there's always more interest. So they'll decide that, Commissioner. But I felt comfortable because what we've added to this resolution is we're going to have a larger fire lane than usual and make sure that's open up, and it's really going to be a scaled down amount there. People were going to park anyways in those spots. We weren't going to have the parking closed off, so we might as well help with pay for the event, and I think it'll be fine.
Thank you.
Any other questions by the commissioners to our chief?
I do have one more comment. I believe the BSD will come to you shortly with probably the next meeting with who the vendors would be for sure, and everything they normally do. They're just waiting to see how the meeting goes tonight.
Alex, did you have something to say? I'm sorry, the screen froze on me. I thought you raised your hand. Chief, I can't thank you enough personally myself. That was great compromise. I think it is, as the Woodward Dream Cruise is going to happen regardless. So, but that's pretty good on our end from our city to really narrow it down, and hopefully it will be controlled well, and hopefully you have enough help. And I hope that everybody stays safe and understand the importance of being safe during this pandemic as we're still going through it. With that, Commissioner Hoff, go ahead, please.
I will move the suggested resolution for the scaled down participation in the Woodward Dream Cruise event.
Okay.
Second.
Seconded by Commissioner Nikita. Any comment by the commissioners on the motion? Any comment by the public on the motion? Seeing none, will the clerk please call the roll?
Hoff,
Yes.
Commissioner Nikita,
Yes.
Commissioner Sherman,
Yes.
Mayor Pro Tem Long,
Yes.
Commissioner Ballard,
Yes.
Commissioner Host,
Yes.
Mayor Boutros.
Yes, thank you. Alex, thank you, Chief, again. With that, we go to under new business. We have item A. This is similar situation what we had previously, Miss Attorney. I think I'm going to have to open the public hearing. Public hearing is open to consider the rezoning of 394 South Old Woodward and portion of 294 East Brown. Ms. Eckert, if you'd like me to save you the explanation, I will go ahead and briefly say that due to improper notice on the property, the RH meeting listed on the agenda will tonight should, by your recommendation, be postponed to another certain date, which is July 12th. But I'll leave you the floor. But go ahead, Ms. Kucherik.
Just if I may clarify, Mayor Boutros.
Yes.
So it came to our attention today by a citizen who noticed that there was not a physical notice on the building of the lot in question. And under our zoning ordinance, there must be a physical notice placed upon the property. And it would have to say that it was a notice for a rezoning amendment or rezoning. The notice did not say that. It was in regards to the previous meeting. And the clarification I want to give is that I want to make sure that everyone is clear that this was not the fault of the city or any of the staff. The zoning requirement puts the onus upon the applicant to put the notice on the building. And it is the applicant who failed to do that, not the staff, not the city.
Okay, thank you for the clarification. Ms. Eckert, would you like to add anything?
No, I believe that covers it. So essentially, without the notice being given properly in accordance with the ordinance, we'd recommend you postpone it to July 12th and allow them to correct that issue with the notice signage.
Okay, Mr. DeMarcus would like to add something.
Yeah, I'd like to bring to your attention that with my previous tenure here, I think the way those signs were worded was that this is a notice of a public hearing, a land use public hearing on this property. And if you have any questions, please call this number. Community development was the number on there. What's happened in the interim between when I served and now is that we got very specific about the nature of the hearing. For example, lot split, lot combination, rezoning, special land use permit, so forth. These are notices on the land that are in addition to the notices that go to persons within 300 feet, plus all the other public notice that goes on. The point in raising this issue is there is a sign posted on the property. The sign, though, is for the lot split, lot combination. And it's my belief that we've created a management nightmare to keep this taken care of. Because each one of these requires a different sign. We actually have stickers, and we go and put these stickers, or the developer puts these stickers on the sign to identify this specific kind of public hearing. I suggest to you, with maybe a fair exception of people in the community, they don't distinguish between the type of hearing that it is or isn't. Now, some might argue that this is a ordinance-driven provision. I'm not sure entirely that it is. And I think that this is something that staff will look at and come back to the commission, because I'm not sure that we haven't missed some other things based on the way this thing is administered. It's a very complicated way to try and do public notification, that you'd have to change it. And again, I don't think the general public has a good sense of what all the differences are and the types of hearings anyway. The objective is to let people know something's going on in this property and it relates to land use. And we want you to know that. And if you have specific questions, please call this number. I think that's the whole point of this additional notification that we make. Having said that, I'd like to thank Paul Reagan for having the tenacity to go out and see this and point it out to us and bring it to our attention so that we didn't default in this hearing process. And as Mary said, or someone said, this had more to do with the pass off to the developer who was responsible for doing or posting and making sure. But we went to, this is literally how it was handled. We did little sticky notes on the stickers to tell them when they had to put them on. I mean, it's overly labor intensive to make sure that this all happens. And so my view is, I think we can still accomplish the purpose and not make it so cumbersome or so complicated that it gets confused like that. Or else you're going to find yourself maybe approving things that weren't properly run through at least the identified due process that we do follow. So those are my comments.
Thank you, Mr. Marcus. Okay, Commissioner Sherman.
I would also point out that in the memo, it talks about the lot split rearrangement, which we already did 3 weeks ago, I believe, before it ever gets into what the purpose of this one was. I know personally, when I read this, I was a little confused as to what we were doing at this hearing. It looked like we were doing a split rearrangement again.
Okay. Well, I'm glad, like Mr. Marcus said, that we're being proactive versus moving forward and not paying attention and being deeper situation and trouble. With that, Commissioner, the public hearing is still open. Any public comment or any of the representative with us, Ms. Ecker, as you know of, or representative of the project would like to say anything, or we're good?
Mayor, Mr. Bloom has his hand up.
Sure. Before I give it to the public, Ms. Ecker, I'm not sure, you were muted. I did not know what the answer. Do we have someone? Okay. Who would that be, that person?
Okay, there we go. I finally got unmuted. Okay.
Okay, I'm sorry.
We do have somebody here. We just have Rick Ratner representing the applicant. I don't think he's specifically looking to speak, but he is here if you have any questions.
Yes. Thank you so much. You were muted, and I'm thinking you were speaking, but I was right. You were. So good. Mr. Ratner, do you want to say anything, or you just, if there's any question, you're ready to answer?
I have nothing to add to what was said, except I would ask that the commission postpone it to the date that we talked about, which was July 12th.
Thank you, Mr. Ratner.
Thank you for your
Yep. Now I'd like to see if there's any comment from the public or discussion. Mr. Bloom, go ahead with your comment, please.
Hi, good evening, everyone. David Bloom, Birmingham. I have two comments. Can we put QR, and this goes to what Mr. Marcus was talking about with the complications of the signs. Is it possible for us, and would it be legal to add a QR code to the signs so that people walking by, a lot of people know how to use them now, can use their cell phones, and they can access a city website and actually get more information rather than having to call? And suppose someone's walking by at 7 o'clock in the evening. Well, you can't call City Hall at 7 o'clock in the evening. But if you can use your cell phone and you can access the city website, you can find out about this, and maybe you avoid having to do a call, and you're providing more information to the public more quickly. So I don't know if that's something that would be possible. The second is that it looks like this hearing is being postponed for about a month, and that gives the city and the applicant a lot more time to have a good discussion about what Birmingham would be getting for rezoning these properties, for the lot combinations and the splits, for the economic development license, for the permission to increase the height of the building. We really ought to be getting something for this. And I want to point out that the city is basically giving away somewhere between $5 and $10 million in free parking spaces we don't have to this developer. And the Daxton got probably even more than that. And the Kajoyan building at the old Varsity Shop got about 50 parking spaces worth of free parking. So multiply that somewhere between $25,000 and $50,000 a space. And we're giving away to these developers, because these buildings are in the parking assessment district, all kinds of parking that we don't have, and somebody's going to have to pay the piper, and that's going to be the residents one day. So let's use this time wisely. Let's not try and delay the project. Let's get to work and roll up our sleeves and find out what these developers are going to do for this property for the city of Birmingham in exchange for rezoning. Thank you.
Okay, thank you, Mr. Bloom. Ms. Ecker, would you like to just comment on the QR code, if possible?
Is it possible to put the QR code on the sign? Yes, it is. We previously had them. The feedback from the public was that nobody ever used them. I don't know if that's true or not, so we took them off.
But that's what I thought. I thought we had them before.
We did have them before, correct?
Okay, so the underutilization forced us not to put them back in, kind of.
That was the policy decision that was made at the time, about a year ago.
Okay, Mr. Marcus, like to add something.
Yeah, usually I don't jump into public kind of comment, but a statement was made by Mr. Bloom that this will fall on the residents or the taxpayers. If in fact we needed more parking, we could return to a special assessment against the benefiting property owners, and it would come to the fees, both the regular fees for daily use and permit parking fees to build additional parking if that was necessary. The properties would be assessed as well. That's a possibility. So I don't know why we would go to the residents for that.
Okay, thank you. With that, I'd like to close the public hearing. And Commissioner Hoff.
I'll move to postpone the consideration of rezoning of 300-394 South Old Woodward and portions of 294 East Brown to the July 12th meeting.
Second.
Seconded by Commissioner Sherman. Comment on the motion by the commissioners. By the public on the motion? Seeing none, will the clerk please call the roll?
Commissioner Hoff?
Yes.
Commissioner Sherman?
Yes.
Mayor Pro Tem Long?
Yes.
Commissioner Baller?
Yes.
Commissioner Host?
Yes.
Commissioner Nikita?
Yes.
Mayor Boutros?
Yes. Thanks, Alex. We go to item B. This is item related to similar of the same property. This is a public hearing zoning amendment to economic development license map 394 South Old Woodward. I'd like to open the public hearing. And Jenna, would you like to add anything to this item?
No, it's the same issue with regards to the notice sign, so we would recommend that you postpone it to July 12th as well.
Okay, great. Commissioner, any further discussion as the public hearing is still open? Public? Commissioner Host?
Yeah, I would like to ask Mr. Ratner if you would, in the next month, maybe you want to do it right now, who is the owner of these properties, the proposed owner? And who is the proposed developer? And could you kindly be very specific in your answers? Who are these people?
The owner of the property is going to be RH, and they're developing it and building it.
So they're the owners and developers.
They're
that
excuse me. They're the owners, and they're deep into the development and building stages.
Awesome. Did that answer your question, Commissioner Host?
Yes.
Awesome. Any further comment or questions on this by the commissioners? By the public? Mr. Bloom, go ahead with your comment.
Thank you. Good evening again. The first comment I would like to make is I'd like to address Mr. Marcus's comment that this wouldn't affect the residents. Typically, the way I have seen the city try and do parking structures in the past has been to issue general obligation bonds, which goes against the city's
dialogue.
Let us focus on this.
It goes against that. Okay. So that's not entirely accurate, or we can maybe agree to disagree. In terms of Mr. Ratner's statement that RH would be the owner, operator, property owner, and developer, Dave Stanchek, before he retired, and he was the gentleman that said that he was from this area, so he wanted this project to go up, and he was the creative force behind doing this project in Birmingham. He's no longer there. And he did say at a prior city commission meeting that the intent would be that they would be the owners now, but then they would, once the property was developed, that they would then sell that property and lease it back, and that was their business model. Just to clarify what had been previously communicated to the city commission. Thank you.
Thank you for your comment. I'd like to close the public hearing and entertain a motion for further discussion. Commissioner Sherman.
I'll move to postpone the public hearing to July 12th, where it will be continued.
Of the zoning amendment.
Second.
And seconded by Commissioner Nikita. Any comment on the motion by the commissioner? By the public on the motion, please? Seeing none, will the clerk please call the roll?
Commissioner Sherman?
Yes.
Commissioner Nikita?
Yes.
Commissioner Baylor?
Yes.
Commissioner Hoff?
Yes.
Commissioner Host?
Yes.
Mayor Pro Tem Long?
Yes.
Mayor Boutros?
Yes, thanks, Alex. We move to item C under new business. We have a resolution to take no action. The current city resolution allowing temporary COVID-19 off-season outdoor dining standards that would expire on June 30th, 2021. Or we have a resolution to extend the current city resolution allowing temporary COVID-19 off-season outdoor dining standards to Friday, September 10, 2021, subject to the following conditions. And we have two conditions in front of us. Number one condition is any temporary dining platform with walls and or roofs must have those walls and or roofs removed by July 9, 2021. Walls and or roofs will not be permitted on any future temporary platforms. Proper temporary barriers will be required to denote the dining areas. Condition number two is heaters will be allowed pursuant to fire department rules and regulations, but storage of propane containers near the dining area will no longer be permitted. With that, I'd like to give the floor to Chief Clemens on that. We have a presentation by our chief. Mr. Chief Clemens, the floor is yours.
Thank you, Mr. Mayor. Appreciate it. Good evening, everybody. In reference to this, the staff got together, which includes police, fire, building, planning, finance, and the manager's office. And we discussed this topic on more than one occasion. So just a brief PowerPoint tonight, just kind of go over some of the things we've talked about. Basically, back when this all started back in April and May, when the pandemic first began, the whole purpose of our outdoor dining program, and really all the different things that the city did to try and assist the business community, was to, in this case, make up for the lost dining capacity from the state of Michigan's restrictions. In addition to that, we also talked about, and we did things such as, waiving the parking fees and structures. For a brief time, we also waived on-street parking. We had the design standards and so forth were waived, and both planning and building worked hard to get things up virtually in light speed in order to try and assist the business community. We also, along the way, worked on PPE distribution through the BSD, and we also had the purchase of temporary structures, gas heaters, and propane tanks to also assist in these endeavors. So, but again, all of these activities were, in our eyes, temporary measures to assist the building community as we navigated through the COVID-19 pandemic. There were quite a few challenges that we came across when we did these things. Obviously, Birmingham has very specific engineering standards, building standards, planning standards that we basically moved through light speed to get those things implemented without really following many of the things that we take great pride in doing to make sure that we dot our I's and cross our T's. So we didn't go through those normal and customary practices. We also obviously had the difficulties, we all know, when it came to what the prosecutorial jurisdictions were with all the different, first the governor's orders and then later the Michigan Department of Health and Human Services orders as to how we could enforce those things. And obviously the police department and the fire department had to work a great deal with getting businesses to work voluntarily to follow those orders. As we look at things now, there is some inequity as they exist, because certain of our business community members are paying for their permanent decks, which have been previously approved by the commission and the planning department and the building department. They're paying for theirs, while the temporary decks are not being charged. Obviously, the lack of the design review has led to some structures that are probably less appealing aesthetically, and obviously functionality is also an issue. One of the things that we obviously look at when we do things by the book, when we follow normal engineering and planning and business or building practices, is make sure that everything is ADA compliant. I think if you go through and look at some of these facilities as how they've been designed and laid out in terms of actual implementation with the width of passage, lack of ramps and accessibility, we may have some ADA issues that we haven't even really encompassed or looked at yet. Some of the specific ones, examples, obviously projects expand well beyond what they were supposed to, creeping into sidewalks, yellow curb zones, and especially on sidewalks. The one picture in the middle, obviously you have a situation, if you add diners in there, if you add wait staff in there, if you add pedestrians in there walking on the sidewalk, you've got a very congested situation. The one on the left, obviously you can see that the planter is into the yellow curb, obviously should not have been there. And the one on the right, obviously when that structure was originally built, it was too far out into the street. To the owner's credit, they did work with the city and correct that and move that to make it more user friendly and obviously make the passage on Euclid safe. Obviously, the other thing is we put these dining decks up, or allow these dining decks to be built, extended down using public parking spaces, and also blocked adjacent buildings, other businesses that were not restaurants or bars, and obviously impairing their visibility and obviously also their ability to conduct business and other uses. And then finally, we, as we indicated earlier, we did allow for, we sponsored some propane program and also the tanks and so forth, and we allowed for some on-site storage of those things because they were getting so much use. And obviously, I'm sure Chief Wells will tell you, there's always concerns when you put something like propane tank out on a public street like that, and who knows what could happen, but it's obviously something we have not done in the past, and hopefully looking forward to not doing in the future. So, June 30th is the expiration date. As you know, in the report that you've all read, I'm sure that I authored, it shows that you've extended this several times in the past. Up until this date now, the dining standards is set to expire on June 30th. One of the things we looked at as a staff going through these things is we all know that the state on June 1st opened some things up, and then the intention of the state, I believe, is that on July 1st, all of the pandemic restrictions will be removed, bringing things back to quote-unquote normal. I think one of the things we're looking for, obviously, with this is that many of the things that we've concerned, things that I brought up here, the interfering with the public right-of-way, blocking of storefronts, use of public parking spaces without paying compensation, and public areas like that for the parking, and also opening up to the retail community to allow them to have their regular store frontage return to normal. In addition to this, the COVID-19 initiatives are coming to an end. Also, other things. City Hall, as you all know, we've started a phased reopening of City Hall on July 1st. The parking decks will resume being charged. Parking spaces will be charged again, and with fees. And also, obviously, after July 1st, we're hoping to return to in-person meetings for the commission and all our other boards. On-street parking spaces that are currently being utilized by these decks will be returned to service. Hopefully that'll reduce some traffic issues, valet issues, and hopefully again assist the retail section of our downtown business community. And finally, I think with the pandemic hopefully slowing down, as the chief has indicated, but certainly not gone by any stretch of the imagination, we can return to our established site plan and design reviews that are done by our staff, by our city boards, and the city commission itself. So I think, again, if you look at the sum total of what we're saying, the whole idea behind this would be, if in fact option 2 is chosen, it would be the only COVID-19 pandemic incentive that the city commission will have approved beyond what has already been done. I think it's a situation that if July 1st comes and the state follows suit, that the temporary situation we were trying to correct and that their numbers were reduced or capacities reduced would be eliminated. I think if it was to move forward, I think it would simply be to try and make up for some lost ground. But I guess that's a decision that the city commission has to make for itself. So with that, I'll answer any questions to the best of my ability.
Thank you, Chief. If you don't mind, Chief, you can take the presentation down so I can see commissioners' hands and in public set forth.
Did that work?
Not yet. It's still on.
Okay. Eric? Oh, there we go.
Here we go. Now I can see more hands. Commissioners, I'll start with you, please. Any question for our Chief, Mark Clements? Commissioner Host, go ahead with your question or comment.
By the way, Chief Clements and Fire Chief Wells, I can't thank you enough for your comprehensive reports. The thing that really moved me in this one was you had to watch all these restaurants very closely, and in your analysis, I feel you were, if you were erring, you were erring on the side of public safety and health and welfare. And I truly appreciate all your efforts to try to get us through this thing. And I love the fact that you're suggesting that we shouldn't continue it, if only because of the 19 restaurants that you put together, there were only 3 of them that were complying with Lansing's ordinances. Thank you.
Commissioners, any other question for our Chief? Commissioner Nikita, you had your hand raised?
Yeah, I have a question. Do we know how many parking spaces, in addition to the normal parking spaces, that in a typical or normal situation pre-COVID, how many parking spaces are actually being taking up, like adding to the normal amount? I'm curious about that because I know that's one of the points that was made, and I was just wondering what the amount of those parking spaces, how many there were. Do we have a number on that? Do we have an analysis of that?
I don't think we looked at it. No, I mean, I think you can. I can go back and find you a number in the future, but I did not look them up for specifically. Obviously, there's parking spaces on Pierce, Townsend, Merrill, Old Woodward. So to get you an exact number, I don't know. And the other thing is some of the enclosures also encroach upon the parking meters that are actually covering the parking meters in other places like on North Old Woodward. So I'm going to say you're going to look at least a dozen.
You may continue, Commissioner Nikita.
Yeah, I mean, my very rough analysis was about 10, maybe 12. So I think that's along the lines of what I was thinking. But as one of the points of concern is the taking of parking spaces. I think that would be helpful to know what that is. The other question was, what's the determining number of why September 10th? What is the determination of that date as the alternative date of extension to that date as part of our discussion? It's either the July date or the potential extension to September 10th. Why then? And then there's been discussion about extending it further. You know, that's part of what I'm trying to get a handle on what the decision making is on that.
I'll let Mr. Marcus handle that.
Yeah, so when we discuss this issue, but first off, our preference is to let it expire when it was suggested at the end of June. We picked September to get people through Labor Day. First off, the assumption is that the state will remove all the regulations July 1st, which was the premise for why these COVID decks and outdoor dining were permitted in the first place. So we were allowing them through Labor Day weekend and then giving them time to dismantle. So that's how we got to September 9th. And to be perfectly blunt, we did not wish to move it to November and then listen to a sustained petition and request to move this throughout the winter again. We think the purpose of these facilities was honorable on the part of the city and was benefiting a stressed restaurant environment. But the basis was on them having reduced, diminished space within their restaurant. That will return. The other point I would make is that in those restaurants, based on our investigation, even when the restrictions were in place for reduced seating and spacing and other requirements, they weren't being followed. So they were over those limits when we went into those restaurants. So that's how we got to that date.
Thank you, Mr. Marcus.
That was an alternative, though. That's not the recommended, option from the staff.
Okay. Please go ahead.
Yeah. So I had a question going back to the directive the commission gave on looking at the ordinance, and maybe this is a question for the planning director, but there was a discussion about revising the ordinance to accommodate some variation on the current existing ordinance that allowed for some of the things that we've seen over the last year and a half or year and whatever since the beginning of COVID, let's say. And part of that is allowing certain things to occur beyond November into the winter, allowing outdoor seating through the year, things like that. So I was curious on what the status of the ordinance revision was, and given that I know that the master plan has taken up the planning board's time significantly over the last so many months, although currently there's a period where the consultant is developing the draft, the latest draft of the master plan. So I think that the planning board isn't necessarily spending as much time on the master plan. So I was wondering if, given the timing of all of this and the interest of the commission seeing that ordinance revised, which would give us guidance to any alteration from what we've done before with what we would do going forward, if that was possibly in the works and could potentially be pulled together in some reasonable amount of time. I have no idea where we're at on that. I'd like to know where we're at, if we could, please.
Mr. Mayor, would you like me to answer?
Please go ahead, Jenna.
Okay. Well, your timing is impeccable, Commissioner Nikita, because it will actually be a topic on the joint meeting at the next joint meeting of the City Commission and the Planning Board, which is currently scheduled for next Monday. The Planning Board has briefly discussed this topic. You did send it to them in December of 2020. They had some questions that they had for the City Commission in terms of what type of enclosures you're looking for all establishments, only during the off season, a bunch of different things like that. So this was one of the things that they requested to discuss with you at their next joint meeting. So we will bring it back for discussion next Monday.
Okay, that's the answer. Thank you.
Yep. Other discussions by, any other discussion by the commissioners? I'll open it to the public. Any questions for our chief, for the regarding the subject, please? Let's start with Miss Jennifer Hammond.
Good evening. Can you guys hear me okay?
Yes, go ahead, please, with your comment or question.
Yes, Mayor Boutros and commission members, thank you so much for your time tonight. My name is Jennifer Hammond, and my comments are pertaining to leaving these outdoor dining structures in place that have been erected by some of our local bistros and restaurants here in Birmingham. I've lived in the city for 40 years, and one of the things that makes this city special to me is the buzz of the people who come into our town to not only shop, work, walk, but also to dine. And if you haven't noticed the recent vibration that has returned to our streets, I guess you haven't been out since the COVID restrictions have been lifted. Not only are these outdoor dining venues providing a lovely and beautiful scene for residents and others who are seeking a change of scenery and fresh air for lunch or dinner, but it also creates an unmatched sense of safety for those who have been locked in their homes for the better part of the last 16 months due to the COVID. And I know that Mr. Marcus said that it fit a temporary need, but I believe that that need continues, especially for the confidence of patrons who want to go out and dine and have the option to be outside. As a person who's fully vaccinated, obviously, I often eat out, sometimes half a dozen meals each week, but I love the option of being able to go outside, especially now. It's like we were cooped up for so long. We've waited for this beautiful weather, and the ability to be outdoors on a patio has given many of us a greater sense of comfort and safety as we continue to put this pandemic in our rearview mirror, although, as some have suggested, it is far from over. If we no longer have access to these patios and pergolas throughout the summer months and into what are lovely fall months, and many of them, I should add, are really well designed. They're tasteful. They often add beauty to the street and the cityscape with flowers and twinkling lights. Many people like myself will be forced to limit, if not discontinue altogether, time spent in our charming city, and we won't really have that same kind of vibe that makes Birmingham so special. So I urge you to please consider in your decision to leave these patios and these outdoor facilities for diners and people who want to seek an outdoor venue for the lovely months that are very limited to us here in the state of Michigan. Thank you for your time.
Thank you, Ms. Hammond. We'll go to Ms. Dolce. Go ahead, please state your name for the record and go ahead with your comment or question.
Hello, good evening. This is Dulce Fuller. How are you? Good evening, everyone. Just kind of want to weigh in here on the outdoor dining. It definitely served a very important purpose over the last, year and a half. But I think it's time to curtail all of the extensions. They do encroach on other people's businesses, and I don't think it's fair. And I can say personally that I understand that, for instance, Toast restaurant, it's very kitschy, and I get it. It's totally fine, but it's an obstacle course for pedestrians, and it's so hodgepodge. It kind of looks like, no offense, because I know it's kitschy, but Sanford and Son. And in fact, in front of our home, our home. We have a large extension of a restaurant. It's very loud. At night, I can't open windows or doors because, in the evening, late at night, it gets, especially on weekends, it gets loud and raucous. And it also is not a tidy site in front of our home. It's hodgepodge. There's trash left out. There are oftentimes dishes left out. It's just not, it's not a nice sight to see. And I'm going to turn it over to my husband, Ted, so he can say something.
Good evening. I think it would be important if they would just return to their original footprint and stop encroaching on the neighbors' fronts. And I think that would help completely. I don't think we're talking about eliminating outdoor dining. We're just talking about bringing it back to what it was originally. I think that does it for us. Thank you.
Thank you, Mr. Fuller. Just for clarification, that yes, this is what we're talking tonight. It's not eliminating outdoor dining. It's more the extended big ones that we're talking about. Where outdoor dining would remains. The discussion tonight is whether to completely remove the extended platform or to keep the extended platform with the conditions that I just wrote, just for clarity of the discussion. And please, for the public, make your comment short, and if you just echo fellow comments and don't be repetitive if you don't mind. For the sake of our business tonight, it's 9 o'clock. But I'll give the floor to Mr. Henke. Mr. John Henke, go ahead with your comment or question.
Good evening, Commissioners. John Henke here from Birmingham. As you know, I've been intimately involved with the bistros during the COVID situation from its onset. I would take somewhat issue with Chief Clemens's PowerPoint that the planning division and everyone associated with that didn't do everything possible in terms of trying to assist the bistros and assist the community in doing everything they could, not only for our restaurants, but the rest of our retailers and our community, in trying to fashion some type of resolution, both the first and second and the third, with respect to keeping the restaurants open, allowing the carryouts and the grab and flies as they did. Having worked with everyone in the planning division and the city commission, you have done a tremendous job of keeping Birmingham open as a restaurant destination through this. What I think is most important is, and what's being lost in all of this, is the need that continues for the next 12 weeks. COVID hasn't gone away. It isn't going away instantly on January 1st or November 4th of last year, as certain individuals intimated. These restaurants are in desperation mode. They have been in desperation mode. They will continue to be in desperation mode. To give them an additional 12 weeks to continue to recover what has been an exceptional circumstance in all of our lifetimes is necessary. To give them to, as Commissioner Nikita mentioned, there are, and he and I did speak, there are approximately 10 or 12 parking spaces that we have sort of given up, right? And I use that term very loosely, in order for the restaurants to expand these decks. To do that for another 12 weeks, to allow them to recover, and for the health and safety of the restaurant community and our community as a whole. I looked at the statistics today. We're only 56% vaccinated. Most people that feel safe, myself included and my wife included, who have been residents since the 80s, only want to eat outside. I don't feel comfortable eating inside, mask or no mask. I need that deck. Most individuals would feel much more comfortable in that deck or on that deck. So, and there are only a few instances, to Commissioner Host's statement that there were 19. There are 36 on the report that Chief Clemens gave us. There are only 6 instances where there was, on May 2nd, possible overcapacity or non-compliance with COVID restrictions as Governor Whitmer has articulated and, through her various orders. So I think it's very important that the restaurant community as a whole, because we are a restaurant destination, continue as such, give these restaurants another 12 weeks. Many other communities in the state of Michigan, 39 at my last count, have opened up social districts to help their restaurants. Across the country, many of them have extended these until 2022 in order to help those restaurants and extend that. The few instances where the commission or planning, or I'm not sure who, seems to be caught up, or a couple of extended decks in front of retailers of others. I understand their consternation. I truly do. But if you look at the other side of the equation to that, they have had a captive audience throughout the winter in front of their stores that they wouldn't have had. So I would urge the commission to at least extend this to September 10th, given that there was some discussion of that date. And again, I would applaud the planning division, the fire department, the police department. Having worked with all of them through this, they've done a tremendous job to keep the restaurants and retailers above board and the health and safety of our community at the utmost importance. If there's any questions, I'm happy to answer them. But as you know, Mayor Boutros, I have been, waist deep in this from the onset.
Thank you, Mr. Hanke. We appreciate your comments. I go to the Klein family. I think Mr. David Klein is with us. If yes, please go ahead. The floor is yours.
Yes, hi, thank you. My name is David Klein. I have the David Klein Gallery at 163 Townsend. The front of my store has been covered for the last 8 months completely. I am unfortunately invisible from the street, and I'm just coming to the City Commission this evening to ask to get my frontage back. As you know, I have an art gallery, and it's really important for people to be able to see inside my windows to see what I have to sell. So I'm asking the City Commission tonight to please take the city's recommendation. I really need my frontage back. I appreciate the restaurants. I love them as neighbors. But having my frontage blocked all this time has really hurt my business. Thank you.
Thank you, Mr. Klein, for your comment. I have Mr. Gerard. Go ahead, please state your full name for the record and go ahead with your comment.
Hi. Can you hear me?
Yes, I can.
I am Gerard Marty. I own a business in Townsend Street. I own the Robert Kidd Gallery. And I kind of disagree with my neighbor, David Klein. I have the same issue. I have the restaurant next door who have extended dining area all the way to my window. And it's bringing me a lot of business. I have people having dinner, looking in my window for a couple of hours when they're having dinner and having a good time. A lot of these people come after dinner into my gallery and buy. A lot of people come also before dinner when they are waiting for their table and wander around the gallery. And since the beginning of the pandemic, the extension of the restaurant next door are probably double my business. So for me, extending it until September would be a good thing. And I have no complaint.
Thank you. Thank you, Mr. Gerard. I have an iPhone, but I can't see a name. Maybe as the screen came on, is that Banjoyo Vani with us, maybe?
It is. It is. Can you hear me?
Go ahead, please state your name for the record and go ahead with your comment.
Hi, my name is Joe Bongiovanni. I'm the operator of Market North End in Birmingham on the north end there. And my family also owns Lux Bar and Grill and Salvatore Scalapini. I thought that there's been a lot of discussions, and so not to be redundant in any areas, I think as an operator, one of the things that the pandemic has taught all of us is the amount of pivots that we've made since we've been open have been substantial. And every pivot that we've made has been in the guest's best interest. our attempt and our focus has been to try to meet the needs of the Birmingham residents since the day that we were originally shut down for business and then reopened. It's certainly been the most challenging period of time for any operator in our business. We're grateful that the city has been really proactive at working and coming up with solutions to try to meet the needs of the residents of the city. And I think collectively, if you view this as a whole, the amount of service that we've been able to provide would also be considered essential. The outdoor decks have been in discussion now for about a month and a half or so, and the resolution that was proposed, in our view, is missing one last link, and it's just leave them as is. The roof and the sides of any of the decks as they were constructed were meant to be so that the guest does not have to move if the weather becomes inclement. During the winter time, it certainly provided a possibility that someone could sit out there in a coat and eat dinner if they so chose. And I guess that anybody watching this video today or this hearing, they were probably at best a 30% group of you that were willing to sit in a coat and under a heater. You're either desperate, non-believer, or whatever. So we kept trying to meet the needs. We really didn't know what the expectation would be. When we were first in May of last year, when we were carry-out only, the carry-out business became so extraordinary that it pushed all of the restaurants to new boundaries and successes and failures as a result. When we got to the fall and we were reclosed down, the difference was marked. It was clear that the business climate had changed from Thanksgiving and through Christmas and the holidays, and our carry-out business was substantially different than it had been earlier in the summer or in the spring. Every time that we've done something in these businesses, we've been pivoting. The advent of the outdoor decks and then ultimately building them with roofs, if we so chose, was an attempt at market. It's 8 tables, and they are properly built according to health standards and the city's approvals, including the original one that Mr. Clemens said was built wrong. It was built wrong because the city approved it wrong, unfortunately. And so we corrected that on their behalf, to be honest with you. But all this being said, we just want to we're finally kind of hitting a routine right now. Our staffs are getting closer to normal, but not yet. And we're feeling something that we can get a routine around. The rest of the summer, if let's say our outdoor dining platform was approved without a roof, those 8 tables are maybe 30 or 40% used. You have varying degrees of elements to contend with, as well as the decision that a guest may not feel comfortable any longer with their dinner being disrupted.
Go ahead,
or something along those lines. I'm sorry to go on, but I'll end
summarize it.
Yeah, and
go ahead.
I guess in summary, please understand it from a restaurateur's point of view. These were the elements that we've contended with along the way. And parking notwithstanding, I haven't heard a resolution asking that the businesses possibly contribute to the parking fund as a result of these parking spots. But I'll leave it at that. Sorry for my comments going long. Sorry.
Thank you so much. Eric, before I give it to, we have one more, Ms. Beth Hussey. I'll give you the floor in a second. My IT department, Mr. Director Eric Brunk, I have your hand raised. I'm losing connections here and there, but I'm not sure if the rest of the commissioner are. But is there something you want to address to us?
Mr. iPhone Nino has been trying to get in the list of hand raised, but I don't think he has the ability to raise his hand if you would like to take him.
No problem. After Ms. Beth Hussey's comment, I will take Nino's comment. How about that?
All right. Thank you, sir.
Thank you. He probably heard me. So good. Ms. Hussey, go ahead with your comment.
Okay, hello, good evening, Mayor Boutros and commissioners. Thanks for the chance to comment. I'll be very brief because I don't want to repeat anything. But the one point I want to make is that I don't know for sure, but when this resolution was set, I think it was a year ago, and I believe that it was probably set to happen for a year. And I don't know, I'm guessing that perhaps no thought was given to the date that it ended, because I can't imagine that if it had, that someone wouldn't have thought, hey, it might not be the best idea to end this in the middle of the high patio season. And then the other comment I want to make is that imagine if you could put yourselves in the shoes of a restaurateur, and imagine when June 30th hits and everyone has to take down their patios and do all that work, and what that's going to look like to people who might not be up to speed with city politics and things like that. Everyone is going to think we're all a bunch of crazy people taking down patios in the middle of the summertime, and our customers are going to be, asking us why, and it's going to make Birmingham, not, in my opinion, not put Birmingham in the best light. And then we're forced to answer the question, we're being forced to take the patio down in the middle of the summer. So that's it. I just wanted to make those comments. Thank you so much for listening.
Thank you, Ms. Hussey. Mr. Nino Cotraro, if you are with us, go ahead, Nino. I couldn't see your hand. Go ahead with your comment.
Yeah, I keep on raising my hand, but I'm not too much of an IT guy. Anyway, I want to say something. Everybody talk on behalf of the restaurant. They did a great job. But I want to say something. I want to thank you, the city commission, to be really upfront. When this COVID started, I think they did a fantastic job, and they're still doing it. But the COVID is not over, like everybody stated. I mean, the people, they're not uncomfortable to sitting inside. So that's the one thing. The other thing is, we spend a lot of money. I personally spend over $100,000 to keep my employees employed through the winter. 36 families didn't go to unemployment or nothing. And now, we have a little chance to make a little money because, in the restaurant business, there's very little money. There's a nickel and dime. There is not the big money that people are talking about. And now we got this issue with all the prices increasing like crazy. And we cannot give it to the customer. And we'll lose a customer left and right. So we absorb the food cost, which is another additional money that we have to incur. And regarding my buddy Dave, my next door neighbor, I love the guy, great people. But I want to say something. I offer him to give him his business card to put every single check from all the customer throughout this pandemic. And also I offer anybody who buys RPs, I was going to give him a free dinner. So I think I was really, I tried to help them, or I try to help him start. All the time it is an issue in life, you cannot blame somebody else for some, not failure, but, you have to reinvent yourself. Like, the guy next door, Gerard did. You open at 9 o'clock, 10 o'clock at night so the people can go in and out. Dave, great guy, but they open at 4 o'clock in the afternoon. I mean, 4 o'clock, we don't even open. So we open, at 5 o'clock. So, I try my best to be a good neighbor, and I'm always going to be a good neighbor, by the way. So I'm hoping that, the commission stay, because I love the city. Obviously, that, I'm trying to take over a Cameron restaurant. I'm going to put a beautiful seafood place, hopefully in September. And I spend a lot of money in the city. I always do. So thank you.
Thank you, Mr. Cotraro. Any other hands risen? I see meeting organizer, but I'm not sure who that is.
Well, Mr. Mayor, this is Kelly Allen, and I am certainly not your meeting organizer.
Yeah, it's just reading meeting organizer.
Sorry about that.
No problem at all. Go ahead, Kelly. Maybe you have to change the setting how you enter the meeting, but it's all good. Ms. Allen, the floor is yours. Go ahead.
Thank you. Mr. Mayor, members of the City Commission, I mean, all these restaurateurs have been through just hell and back, and they're not back. And I know that the city was getting inundated today with several of my folks who were getting petitions signed over the weekend and that, and they all worked hard on that. And I don't want that to be lost on the public that's listening to this at home. I think Hazel and Green, Beth Hussey, who spoke before, got almost 1,000 signatures over the weekend of people, Birmingham residents, non-Birmingham residents, customers, friends, that are supporting Beth and others like Beth in the city that want to continue this. So that is the only topic that I wanted to raise, as it wasn't placed in the record earlier. Thank you.
Thank you, Ms. Allen. Now I see your name. All right. With that, I'll bring it back to commissioners. I don't see any other public comments. Commissioners, for the sake of time, just want to remind you it's 9:20, and let's keep our discussion short, but let's hear from you. Any commissioners like to make a comment or have questions? Commissioner Hoff.
Well, I have listened to all the restaurateurs, and I think we have terrific restaurants in Birmingham, and I patronize them, and they've been doing a great job. And I think it's already been recognized that the city of Birmingham has done what it can to support all of the businesses in Birmingham during this difficult time. But that said, I appreciated Chief Clemens's PowerPoint and the points that he made. I had written down today my points that I took into consideration in trying to make this decision, because it is a very difficult decision. We want our restaurants to continue to thrive like they've been doing. I walked around this weekend, and of course, because the weather is beautiful, you were all filled up outside, which is great. But we also have to think of visitors coming to town who are not going to restaurants and businesses that are trying to survive. There seemed to be a misconception that if you have to take down these extended platforms, that is going to eliminate outdoor dining. That is absolutely incorrect. We're not eliminating outdoor dining. In fact, bistros are required to have outdoor eating areas, and so they will continue. But the list that I made, many of the same things that Chief Clemens said, is when I walk around, the walking path that is supposed to be there is sometimes very difficult to get through. There are obstacles in the way. It's not easy for pedestrians. There are some restaurants that have people waiting for a seat and they're standing in the walking area. So that's one thing. Also, I'm very aware of the parking spaces that are being taken up. I know it's been said tonight that there's 8 or 10, but without accurate information, I'm not assuming that it's only 8 or 10. We're taking up parking spaces, and now that the city is, that people are coming out again, we need those parking spaces. Also, I'm very aware that there have been some violations. I'm not going to say a lot, but there have been some. I've gone into some restaurants where a couple months ago, it was shoulder to shoulder, and that was beyond my comfort level, and I left because they were violating the 50% capacity indoors and the 6-foot social distancing requirement. So with all of that in mind, my opinion is I'm in favor of going along with the first resolution to take no action and to have the temporary COVID-19 off-season outdoor dining standards expire on June 30th. And I've explained my reasons, but that's what I'm in favor
of. Commissioners? Thank you, Commissioner Hoff. Other comments? Commissioner Nikita.
Yeah. A number of the issues that have come up, and I'm just thinking through them, and you know, we've been given a option, which is to essentially take away all of the revisions that we've allowed for the last year, or allow them all completely to continue for another 2 months or what have you. So that's kind of the two options. The question I have is there to what degree is there an alternative or something that actually addresses a number of the key issues that I think have come up. We have some particular issues of encroaching on adjacent retailers. Now, I know that of all and however you want to count it, 36 or 19 or however you want to count it, but there's plenty of establishments, of which really I believe only 2 that I know of are actually encroaching upon the directly adjacent retail space, which has never been approved in the past. I mean, our bistros are very clear about falling within the guideline of the width of their space, not encroaching on the adjacent space. So there are a couple that clearly are beyond where they should be by our normal ordinance, but could potentially address those. And then there are all of these others that are not doing that. The amount of parking spaces, I think, is somewhat limited, but there are issues like ADA compliance, which I think is very important. The 5-foot clear issue is really important. The exposed storage of propane and other things, miscellaneous service elements and such that are on the sidewalk that are very haphazardly done, and that's problematic. Extra seating that may or may not fall within the guidelines that we've put together. And I think more importantly, the idea that design review or aligning with the ordinance and enforcement, which is enforcement can only happen if we have an ordinance that's clear, that's been adhered to. But because there's been such a sort of a loose way of building out a number of spaces over the last year in a few months, that it's hard to really enforce. So these are the areas where I think that we really need to come to grips with changing. At the same time, I question whether or not we have to go to the point of clearing everything back to, a year and a half ago point. So I guess I open up the question to the idea that can we create a revision in what we're doing that we can allow a number of these things to be required to be addressed that are really quite important. And I think we've been looking the other way for a reasonable amount of time. And I think that we've really tried to accommodate, but it is definitely time to address a number of those key issues, but still open up the idea that maybe in some cases or in to some level, we can allow some of the expansion that we've had. So I'm asking the question of maybe something that might be neither one of the 2 options that we've had put forth in our packet, but something that might address a number of these issues and be essentially an in-between, at least for the near term.
Commissioner Baller, go ahead. And then Commissioner Nikita, I will refer your question to the staff and see who can answer that question. And I see your point where it's coming. I'm not going to end it here but let's hear other commissioners and we'll get back to see who can answer your question. I see what your intentions are. Pretty much very clear that yes, we do see an issue with the encroachment, but only happening with 2 establishments. Can we work with this 2 establishment? Can we revise the ordinance? Beside the others are not. So let's pause on that thought. Hear from other commission. We'll come back to you. And many other things that you also mentioned on the enforcement and the ordinance that it's in place that really can put everybody in their place, and now we can enforce it versus we were in the pandemic and we did not have the authorities to do so. I don't want to be repetitive of what you mentioned, but it's very clear what your intention were. Commissioner Ball, go ahead with your comment, and then Chief or Mr. Marcus, whether Chief Paul Wells or Mr. Clements want to answer Mr. Nikita or Mr. Marcus, I'll come back to you. Commissioner Ball, go ahead.
No, I'd rather hear from the city manager or Chief Wells.
Okay. Do you want to go ahead with your comment, or do you want him to go ahead and answer the question, Commissioner Baller?
No, I'll hold off for now.
Okay.
If there's something that either of our administrators have to say, I want to hear.
Sure. Who would like to take the pleasure to answer that question? Mr. Marcus, go ahead.
Yeah, I think one of the points I heard Commissioner Nikita say is we didn't enforce. Enforcement was absolutely confused as to what jurisdiction should have it. And I think that came about because, and I don't think Chief Clemens made the remark that was suggested by him by legal counsel representing the restaurants. I don't think he was disparaging our planning department at all. I guess my concern is that, the restaurants talk about their concerns, their rights. At the same time, they haven't just, and it's more than two, by the way, Commissioner. I can think of Dick O'Dow's as another one that's stretched as well. And I think they had an understanding with the adjacent retailer, so that hasn't been an issue. But they've imposed on the public's right as well, the public's use of their facilities. And, I've mentioned things to different persons that are connected back to the restaurants. They understood our point, didn't get changed. In fact, more of it occurred. So you have a number of places where they have absolutely infringed on the walking public's right to use a sidewalk. And I mean, all you have to do is look around and you know what I'm talking about. That needs to be absolutely cleaned up. I personally made the issue about 220's deck. They actually built it right into the yellow curb. They turned around after we had them cut it back, and now they put boxes out in the yellow curb. We don't allow cars to park there, but now we have permanent structures located there. I could be sympathetic towards the restaurants if they hadn't taken the mile when given the inch in some instances. Some never asked for the additional decks. So we have this spectrum across how these folks are operating, and you can pick and choose those that don't violate, and we can look at those that do. And unfortunately, it is a one-size-fits-all kind of resolution to these issues. All of a sudden you want us to enforce when there's been a question, how do you enforce that which isn't written down or agreed to? I think that's part of the conundrum. And in fact, I think the staff was basically backed off from enforcing during this period of time. The other deck, quite frankly, that I observed was out into the road way further, and it was a misinterpretation as to whether it was going to be on Woodward or on Ravine. It ended up on Ravine, and I think the presumption was it was going on Woodward, so it was built way too wide to handle on Ravine, and they had to cut it back. So I know what enforcement's about because I've been doing some of it myself. The whole point of this to begin with, Commissioner, was that we were offsetting the space that they lost. At the same time, go into these restaurants. They claim that people don't want to go into the restaurants. They want to dine outside, except they're also inside and they're on the outside too. We've created an environment now where you have wonderful, probably from a walk, from putting customers on the street. You probably have more customers in these places now than they had before all this, because you have way more seating than some had. Look at Townhouse. Compare the seats outside to the seats inside. Do you want us to start requiring them to go back to the standard that exists for outdoor dining? They're way beyond the seating outside than they have on the inside. So I think those are all concerns that we have. So you know, you have the choice as to how you want to do that. If you want to impose additional enforcement on our part, I would say that you should impose more requirements for enforcement of at least a 5-foot sidewalk. You should impose requirements that remove any obstructions into yellow parking zones. I still believe that, you know, people want to be outside, let them be outside. Why are we going to leave the roofs and the walls all up in these? Open it up. Okay, you want to be outside? That's the way most of the decks were to begin with, the approved decks before these decks were allowed. Finally, I'd say I think the city has been very generous in the process of helping these restaurants get through. So that's my thoughts on it.
Commissioner Butler.
Yeah, I'm a big proponent of the restaurants in Birmingham. I patronize many of them. I like to take credit for some of the enactment of the bistro ordinance in the first place, and I think we need to take a look at the bistro ordinance and correct some of the problems we have with it. It's interesting. This is all about dollars and cents, but we haven't been presented with any data on finances. No restaurant has come forward and shown us their income statement for the last year. I'm not sure I expect them to, but you'd think they'd at least be telling us their revenue is up or down or in or out or something. I did hear somebody talk about costs going up, and that's true, but I also see menu prices going up. So I also am curious, and I don't know if anybody wants to answer this, but Ms. Hussey is advocating for this, but as far as I can tell, her restaurant doesn't even have outdoor dining. I'm confused about that advocacy. Go ahead.
Mr. Marcus, like to answer.
I think she has some seating. That's Hazel, right?
Yeah.
She has some seatings in the entryway into that area on either side, and then she has some seating out, I think, out on the sidewalk area. But it's fairly recent. Okay. And there was a news article talking about it starting on a certain date, and it didn't start on that date. It was delayed for whatever reason. The other thing I'd tell you is you have another one in the queue, and we've approved one for what's the Beyond Juice. They put up a deck to put 4 chairs out on the deck, and we've already been over there enforcing that they've had too many chairs out on theirs too. You know, we've had a lot of pushing of the limits on this, and I think that's what you get when there's, you know, reduced enforcement.
Okay, other commissioner comments? Commissioner Nikita.
Yeah, I guess I don't know if I got my, I don't think I got my answer. I heard the manager mention a number of the things that I said that I'm concerned about, the 5-foot clear, extra storage, propane, what have you, being able to put together an enforcement situation, ADA compliance, making sure that we're not covering up other spaces if they've encroached, and whether it's 2 or 3 or 4, I'm not suggesting it's any particular amount. My question is just that I don't think it's 36. So my only question is there a way that we can come up with a solution that's neither here nor there? And I still, I guess I don't have an answer, because I think that there's ways of addressing some level of the concerns that I completely concur with the manager and the chief in terms of fundamental ways of safety and clearance and requirements that are basic to the way we should run our city, which is all the things I just mentioned. But does it mean we have to clear everything out, or is there something in between? And I'm asking the question. I'm not advocating one way or another necessarily, but I'm asking if, other than the one option and the other option, which are both sides of the situation, is there some way that we can do something to address those particular fundamental issues and still allow for some level of enforcement and move forward?
Commissioner Nikita. Yes, Mayor Pro Tem Long, I'll give you the floor in a second. Just for a clarity question, resolution 2 that we have, it does allow the extension as it is for the patio, where they extended already, but there's 2 conditions on it where we take the walls or roof. You're suggesting to keep the walls and roof and find a compromise to really identify all the obstacles and hold people responsible from whether it's a parking space to any violation, to any encroaching, to any other things. Is that your suggestion?
Well, I guess I'm not specifically saying it's particularly all of those items, but I'm asking some level of essentially a compromise between 1 and 2. So whether it's keeping the walls or taking the walls and roof down and addressing those other items, but still allowing some fundamental nature of the capacity in a number of those, as long as they're not encroaching upon the level that they are in some of the cases where they're taking up spaces at adjacent properties and blocking views and things like that, and enclosures and passageways, all of those items. So I guess it's a little unclear as to what this entails, but I'm open for the idea of maybe some level of a hybrid.
Got it. Let's hear from Mayor Pro Tem Long, and we'll come back to Commissioner Nikita. Go ahead, Mayor Pro Tem Long.
Thank you. So I'd like to point out that, the first iteration of our temporary COVID-19 outdoor dining standards restricted people to exactly the seats that they had lost on the interior. And then our second iteration was much more generous and allowed people to basically, populate with the number of seats that they could get. And as City Manager Marcus has pointed out, and many of us have experienced, some restaurants, I think, went beyond what any of us as commissioners expected they would do with that gift. My concern is that we had a very carefully designed bistro ordinance that clearly maintained the distinction between the Class C restaurants, who paid for their licenses, and the bistro licenses who were allowed to apply for them with a specific small size to enliven the downtown and help promote the general health of our shopping district, and that the current situation completely blurs the line between those two, and I would be concerned about that difference being institutionalized. Many of the bistros have huge numbers of outdoor seats compared to the inside, and I think that is an issue. If we take no action and allow the standards to end on June 30th, then we would go back to the pre-existing footprint, which would continue until November, at which point we would hope that the planning board would have looked at changing the bistro ordinance, perhaps recommending changes to the ordinance and allowing, as Commissioner Nikita has said, I think we're all interested in allowing some version of outdoor dining in the winter, but going forward in perpetuity, but not the way that it looks for the COVID extensions. To Commissioner Nikita's suggestion, is there an option that's neither 1 nor 2? I guess I would have a question for Ms. Kucharik that if we maintained condition 1, and I do believe the walls and roofs should probably come down and we should go back to umbrellas, because that's what outdoor dining was
intended to be? And condition 2, could we add conditions, 3, 4, 5, 6 about removing seats to allow the 5-foot walkway, removing encroachments for the yellow curves, as City Manager Marcus has put out, and then to address the encroachment in front of businesses. I'd like Ms. Kucharek to specifically answer, could we construct this ordinance that would require some places to remove part of their extension, such as I think Bella Piatti in front of the David Klein Gallery and the one in front of the Schechter Financial Building, and I believe there was one more, and not require other people to reduce their platform sizes. Is there a way to do that that is legal and defensible if we try to rewrite ordinance option number 2 or motion number 2?
It's funny that you called on me, Mayor Pro Tem. I was about to raise my hand that so many of the issues being raised are already addressed in Article 4 of the development standards on the zoning ordinance. I've been reading through it throughout this discussion, and it speaks clearly to, and not just to bistros, but all outdoor dining regarding the 5-foot right-of-way and the ADA compliance. We also engage in the outdoor cafe license agreement with each restaurant that wants to have outdoor dining. And in that license agreement, it also details what one has to do to encroach onto their neighbor's property, and that they have to get the permission of the neighbor to encroach on their property. So instead of adding more conditions, if it were that at least the walls and roofs come down and the heaters have to be stored, but that we return to the outdoor cafe license agreement and we return to enforcing the outdoor dining standards, what we already do and what we already have in place would address all of the concerns that each of you have stated. So I don't think we would need to add more conditions. We need to return to enforcing and living with the standards and agreements that we've already had in place. As far as your question, could we extend it or not? That again is already provided for in the license agreement, that if one restaurant was able to get the permission of their neighboring business, then they are allowed to do certain things. To blanketly choose who gets to have a longer platform and who does not without that permission, I would not recommend.
Go ahead, Mr. Marcus.
Mary, the concern I have with what you're saying is that presumes that it's gone through the deck or the outdoor dining of an establishment has gone through the process to secure a permit through review by the plan board and then ultimately approval by the city commission. We have an entirely different structure here for these temporaries. Now, so the ordinance was excluded when we issued those permissions for those facilities to be built. What you're referencing is outdoor dining that has gone through the process, correct?
Yes, it has gone through the process.
These haven't.
Correct. But what I'm saying is that instead of enumerating, and I'm sorry, maybe I'm not expressing myself clearly. Instead of enumerating more conditions, the condition would simply be that they have to abide by the ordinance that's already been established for outdoor dining. So if the hybrid is to go with number 2, instead of adding conditions, the condition is simply to abide by the ordinance already written, which would then give us the clearance within the sidewalks that would give the pedestrians the ability to walk, etc. So I guess it's more of a notice to the restaurants that they're going to be held to the standards of our ordinance.
But as a practical matter, I would think that many of the restaurants would ultimately have a lot of difficulty complying with that as well, based on what they've done in the with a lot less regulation already. I'm not sure a lot of them could comply. And then are we saying to them, then therefore they don't have to go through review going on? Do they get to continue, like, you know?
No, what I'm suggesting is that that would be one of the conditions added to resolution 2, that it would be condition number 3 for resolution 2 is that they must comply with the ordinance dining standards as already passed and resolved by the city. And that they would have to abide by the license agreements that they had all done last year in order to have outdoor dining. Or if the resolution 1 of no action were to occur, that each restaurant is going to have to go through the process of getting their license agreement in place for outdoor dining, and then they're going to have to comply with all of the conditions that we're even talking about. The answer is yes, we can add more conditions, but we can simplify the conditions by enforcing what we already have, or taking no action, and the restaurants then can continue outdoor dining by going through the process that they went through in non-COVID times.
Mayor Pro Tem, would you like to add something?
Yes, so Mr. Kucharik, you're saying that the restaurants would have to engage with the city for permissions with both resolution 1 and resolution 2. I guess I would like to hear from, if it's possible, from Ms. Ecker, if she thinks that it is possible for resolution 2, how the planning department thinks they might implement that if they if we left it with 1 and 2 and then adhere to the existing ordinance and licensing agreement. I mean, can we practically implement this?
Well, can we practically implement it? Yeah. Could we do it? Yes. Would it be practical? No, it would be difficult. This has taken up an inordinate amount of time, obviously, in going through all of these applications and getting everything finalized. And then, of course, going out and trying to enforce them all, and they change on a daily basis. Time, not necessarily.
Okay, Commissioner Sherman, haven't heard from you. Commissioner Hoff, I'll come back to you. I'd like to hear your comment, and then I will comment after each commissioner have given his comment as is normal, but I'll wait till I hear from all of you. Commissioner Sherman, go ahead, please.
Thank you.
Sorry about that. Yes.
I've been listening to all these comments and back and forth, and unfortunately, we have a situation where we gave the restaurants the ability to expand their outdoor dining in order to deal with the situation that we were faced in the pandemic. And now we have that unenviable task of having to draw that back. And anytime you give something and try to get it back, there's a considerable pushback, especially where in some cases that what was given was then taken to the nth degree. We have structures that were built that blocked meters. We have structures that look like they were hunting blinds. And while taking down the roofs and the walls take care of some of those issues, I don't know how that's going to take care of the issue of ADA compliance. It's going to take care of the issue of providing that the bistro restaurants seating is in accordance with the bistro ordinance, as opposed to and compared to the regular restaurants, which is something that when we enacted the bistro ordinance, we did make that commitment to the other restaurants that these would be smaller restaurants. Now you weigh that on the other side with people seem to really enjoy the outdoor dining. And I think that, or knowing that this is going to be on the agenda when we meet with the planning board next week, that's something that can be discussed. But in the meantime, we have to get to a point where we are in a position to have a starting point for these restaurants. And that starting point is what we already approved. And it was approved when each of these restaurants came before the commission and obtained their bistro license. So it seems to me that when the governor and the state terminate the COVID restrictions and we go back in July to a public meeting in person, that these additional benefits that we've bestowed upon some businesses need to be reeled back to where we were at the beginning. It's fair to them, it's fair to the Class C licensees, and it's fair to the other merchants that are having their frontage obscured by some of the structures that have been built. So I think that would be the appropriate step. I say it reluctantly because I, for one, have enjoyed the outdoor dining. I'm all in favor of as much outdoor dining as we can get, but there's an element of fairness here. And I think that's where this has to fall.
Thanks, Commissioner Sherman. Any other commissioner comment? Commissioner Baller. Unmute yourself, please.
Yeah. Look, we're being put in an odd situation. We bent over backwards and we succeeded. And I think that we lost very few restaurants. I think we could a couple. And I feel like, I feel like a dad who doesn't get thanked for all the good he does. And, the kids just want more. I agree with Commissioner Sherman, Commissioner Huff. I do think we ought to get right on it. I much would have preferred spending time tonight, workshop time on bistro. And I think we should schedule a workshop on the bistro or talk about it with the planning board or both, because we do need to make some adjustments there. But I think the first option is we don't do anything, right? No motion, no resolution. We just sit mute. Is that correct?
What was the question, Mr. Baller?
The question is, the first option is we're not making a motion. It's just we don't do anything. There's no motion made. Is that correct?
Yeah.
I think that's correct. And so, I think we should declare it a success.
Take no action, Commissioner Baller, means you're ending the extension of the patio as of June 30th.
But there's no motion necessary to take no action.
Correct, if you take no action. So let's hear from other commissioners, and I'll give my 2 cents on this. Commissioner Host, I didn't hear from you, but Commissioner Hoff, go ahead.
I also want to say that I think we're a little bit under the gun on this. We don't have another meeting before June 30th when these standards expire. So, if we had started talking about this and making a plan of what we were going to do, we'd be in a much different position than we are now. This is the meeting where we have to make this decision because they expire on June 30th. So
we have a meeting on June 28th.
Okay. All right. And we do have one more meeting if we thought that we would come up with something different. And I want to ask a question in related to what Commissioner Ballard just said, that if we decide on number 1 to take no action, we don't do anything, or it's listed as a suggested resolution. Isn't it a motion to take no action?
I think technically you do not have to vote on anything because the resolution says it's expiring at the end of June anyway, but I'll let legal counsel correct me.
No, that is correct. You passed a resolution that allowed for these temporary outdoor dining standards with an expiration date of June 30th, 2021. If you
That
take
would
away,
remain in effect.
right, it remains in effect till June 30th, and then it ends based upon prior resolution, so no action is needed tonight
Okay.
to stand by your original action.
And may I ask one other question? What would be, if that's the way it ends up and we take no action and expires June 30th, then what would the restaurants do to comply? How much time would they have? What would be expected of them?
I think that would be, we'd have to give them a reasonable amount of time to remove the structures and any of the extensions beyond what originally is approved. That would be approved as a part of the ordinance process. So they'd all get the letter that they had to remove the structures that were permitted as a result of the COVID relief, and I'd say we'd give them 2 weeks.
But then they would be allowed to go back to the way they were before. They would have their platforms, right? They don't have to get approval for those platforms.
Those that had been previously approved for something, not all of them have outdoor dining. Right, Jana?
Correct. She's nodding her head.
Don't the bistros all have outdoor dining?
So, required.
Yes.
Do all the restaurants have outdoor dining?
Not all the restaurants, all the bistros.
All bistros, yes. Okay.
All bistro leases, yeah. Commissioner Host, well, guys, it's 10 o'clock and we probably need a motion to extend the meeting to continue our conversation. But Commissioner Sherman, go ahead, please.
I'll move to extend our meeting by 15 minutes and no more.
We have a couple items on the agenda after that, and we have a closed session. Are you suggesting we don't meet for closed session?
I'm saying, I'll tell you what, how about 15 minutes plus the closed session?
Okay, that makes sense.
Second.
Thank you so much. Seconded by Commissioner Nikita. All right, Commissioner Host, do you have any, will the clerk call the roll on that?
Can we have comment on that motion? My comment would be that, or my question would be, does that motion forestall another motion to extend?
Yes, that's the intention.
I would not support that motion.
Okay, any other comments? Commissioner Host?
Commissioner Sherman, would you be willing to go to 10:30 in the closed session after that? Pretty please.
No. Sorry. It's, when we did the workshops, we had agreed that we would end at 10 o'clock. And we have struggled to end at 10 o'clock. We've usually had to do these extensions, including one where Commissioner Hoff, who was out of town, left at the end after one of the extensions. So I think as a courtesy to try to let's try to stick to a time period here. We should be very close to reaching a resolution here. If it means that we have to kick an item to the next meeting, we kick an item to the next meeting.
Commissioner Host, and you can always make another motion. So let's not indulge on the time right now. Let's move on. And I'd like to make my comment and hear your comment, Commissioner Host, so we can put this behind us and move on.
Don't we have to vote, Mr. Mayor?
Yes, I am calling for the vote. Will the clerk call the roll on extending the meeting for 10:15 plus the time needed for the closed session?
Commissioner Sherman?
Yes.
Commissioner Nikita?
Yes.
Commissioner Hoff?
Yes.
Commissioner Host?
No.
Mayor Pro Tem Long?
No.
Commissioner Baylor?
I changed my mind, yes.
Mayor Boutros?
Yes. Okay. Motion passed. Now we can continue our dialogue for Commissioner Host. Please go ahead with your comment.
Certainly it would be nice, like Commissioner Nikita says, to do a hybrid. However, as it has been pointed out, we have bent over backwards for over a year, and we have joyously followed the law that came down from Lansing to a T, and we should continue to follow that law, and that law is that this ends June 30th. I recommend no action.
I'll start my comment and hopefully we'll
Can I ask you a question, Mr. Mayor, before we do that?
revisit some. Oh, go ahead, Commissioner Nikita.
Just wanted a clarification on the process here. My understanding, based on what Ms. Ecker said and our earlier discussion, is that we will look at, and I completely adhere to the concerns of the manager in terms of enforcement and aligned with an ordinance so that we actually have something with teeth that can be addressed. So getting back to the question of moving forward, it sounds like we can, in the next meeting with the planning board, can possibly address the revision of the ordinance. So if this goes back to the original agreements that everybody had, then we can actually hopefully expediently address an ordinance that addresses some of the things that we've talked about going forward. And we can have that discussion with the planning board next week, which would be sort of a foundation to move forward and address potentially some of these issues that we think may be beneficial to all of our establishments. So is that true, Ms. Ecker? I guess it's a question for her. Mr. Mayor, I'm asking her.
Go ahead, Ms. Ecker.
Well, we could definitely start the discussion, and as you pointed out earlier, we don't have master plan discussions on in the next month or two at the study session at the planning board. So I think once the planning board gets some detailed questions answered from the commission with regards to their direction, we could move forward pretty quickly with the ordinance amendments.
Thank you very much.
Thank you, Ms. Ecker. Mayor Pro Tem Long.
But, we have an ordinance as it exists. We've heard that it's not really practical to redo it tonight on the fly to allow any extensions. And while we can have these discussions with the planning board next week, I don't want to leave the impression, unless that's Commissioner Nikita's intention, that forestalls anything expiring on June 30th.
Mr. Mayor, can I make a comment? I know maybe this answers Commissioner Sherman, or Commissioner Nikita's earlier comments. He was trying to get answers. We met, like I said earlier, the police department, the fire department, planning, building, finance, and management. We all met together and we discussed all the hybrids that Commissioner Nikita talked about. Can we modify this? Can we modify that? And we came to the conclusion, based upon all these things, that you've got to go back to back. This was a temporary thing. And are we going to continue to monitor or modify things that were already supposed to be temporary to begin with? So as a staff, we felt, no, we've got standards, we've got ordinances in place, we've got all these things that the building department has, that the planning department has, and that police and fire then eventually go out and enforce if need be. But so I think the answer to Commissioner Nikita's question is no, the hybrid thing really isn't an option given the fact that this is a temporary nature. If changes to the ordinance come forward as a result of your planning session, yes. But for these purposes, for the temporary COVID-19 decks, I think staff looked at those things, we analyzed those things. In our opinion, this isn't the time to do those hybrid things. They were there for a reason. I think we did a great job in doing those things. And I think that time that we felt this was the time that would come to an end. That's why you have that before you at our recommendation. But could you want to enhance things or change things in the future? Absolutely. But not as they relate to the COVID-19 decks. So I just want to make sure that hopefully that answers your question, Commissioner Nikita.
Mr. Mayor, I appreciate the answer. That's exactly what I was looking for. Thank you very much, Chief.
You got it, Commissioner Nikita. I think we spent enough time on this. We've heard from each one of you commissioners. We've heard from restaurateurs. We've heard from several business owners that really been affected by this, and only, like I said, couple, maybe three, that been encroached on. I do believe, commissioners, you have forgotten one important things. You are acting tonight as COVID is over. COVID is not. I'm in healthcare profession myself, and I do have a waiting list on vaccinations of people, including kids. I do understand I'm also a business owner, and I know what P&L is and how to make money in a business. It's been a difficult year. We all have, thankfully, thank God that we are here also on Zoom. We're all healthy. This is important. You know, we all in the fight together. I don't want to take a side, as you all said. We've been put in a difficult position. We need to make ends meet on P&Ls, and people make money. Restaurants been suffering for a while. This is the time for them to make the money. You have no idea, and you probably do, how many compliments I have personally as a resident, not just as a mayor, that how a wonderful job you mean all of us as a team, as commissioners, as leader in the community have done in the city. They're complimenting those beautiful extension of the patio. It's creating life in our city. It's bringing life back. People have been isolated for a year, almost a year. They're looking for a daylight. They're looking for a patio to sit on. They're looking to mingle with neighbors. I do support at least, and not forgetting that we're still in the pandemic. And if anything, we go with resolution number 2. Keep the extension, because I really sympathize for the business also that have been encroached at. I don't want any business to get taken advantage of. Never. I don't want to make money on the price of my neighbor. Therefore, I believe at least the resolution 2 is a compromise. Keep the extension, keep the vibrancy, let the business people make their money that they lost 12 months of revenue, almost. They're start breathing, the oxygen start flowing. I echo Commissioner Nikita. Had we have time, I would even go to June 28. Let's table this to June 28. Let's think of a more thoroughly resolution, maybe that meet what also our attorney had suggested. Maybe we'll just add that we'll go with resolution number 2, and we comply with the ordinance as we had an ordinance in place, but we're just having an extended patio. If the walls and the roofs on encroachment, that's what's causing the biggest problem. I do believe as a community leaders here, we can communicate with those 2 or 3 establishments and their neighbors and find a resolution. Let's not generalize all our decision tonight based on 2 or 3. We are here to help them, and I'll make sure, I personally will make sure that communication would happen from the city and from the neighbors, and make sure there's no walls and no roofs encroaching on the neighbor that hindered their business. I think, yes, Commissioner Sherman, I appreciate that you did a extension for our meeting. This is a very important decision that we're making tonight. I have to put myself as a business owner. I own that restaurants, and here I am under the mercy of a city commissioner that's gonna make a decision for me tonight, whether to make a living and whether to stay in business. This is very difficult on us, very difficult. I think a compromise is a solution. Yes, we bend backward for every business restaurant, but yet this is the time for them to make the money. This is the time we show them we still care. I think a compromise, I'm saying a compromise should, and we can find that solution. It's not that difficult. It really not. I've listened to every issue that we had, from violation to walking path to parking spaces. Guys, we're dealing with 10 parking spaces in our city. I believe right now we have 30 to 50% of vacancy in our offices use. We should not be talking about parking issues right at this moment. And all what we're asking is to postpone this till September 10. We're not saying 2022. I mean, this is the least, I think, as a leader, we should consider doing this. And I think the city manager, the staff, our chief, I can't thank you enough. You came with a compromise resolution in front of us. You thought it through. You really did. I think as a hybrid, this is a hybrid. It's right in front of us. But, yes, sir. Oh, sure. So, we do have 3 more minutes on this, and I want you to reconsider where you're at, commissioners, and see what we can come up with. And if I can finish this in 3 minutes, let's do it. If not, I'll entertain another motion. But Commissioner Hoff, go ahead with your comment.
I was going to say, Mayor Boutros, you spoke so well about your point of view. I think, in my opinion, the thing to do is to take a vote. We weren't going to have a motion, but you have to get some direction since we only have a few minutes. Do we postpone this or do we make a decision tonight? So that would be my suggestion, that we get a vote from the commissioners on which way we want to go.
I mean, commissioners would like to entertain a motion, if there is a motion. Commissioner Host.
I think with what you said, Mr. Mayor, maybe we should table this to the 28th meeting, if only to work on the hybrid that you talked about. You know, I did a tally. We have 48 restaurants and 17 are in compliance, 31 are not. So you could have 2 weeks to work on those the 31, the vast majority who are not in compliance.
Commissioner Hoff.
Yes, I'm going to make a motion for take no action. I'm going to make that motion. We heard from our police chief. We heard from our city manager. I heard from several commissioners. I don't know if it'll pass or not, but I think that it's important as commissioners to take some action, to do something.
I hear you, Commissioner.
If it doesn't pass, it doesn't pass. Maybe there won't be a second.
But they also recommended to you the hybrid, which is number 2. I mean, I'm not sure, but it's your, you have the right to make the motion. There's a motion on the floor. Is that a motion, Commissioner Hoff?
Yes.
Okay, she made a motion to take no action. Seconded by Commissioner Sherman. Any comment on the motion by the commissioners? Mayor Pro Tem Long.
So if we take no action tonight, that does not prevent us from discussing it again on the 28th?
That's a good question, and I do not know the answer to that. As it's.
Yes, you can discuss it on the 28th, even if you take that motion.
Discuss it in a term, Mr. Marcus, we can bring back a resolution with, let's say, item 2 with some modification.
You can discuss it. You'd have to give direction to do more than that.
Well, let's be clear on that. Okay. Good question. Any other comment or question on the motion from the commissioners? Commissioner Baller?
Yeah, I'd like to see the restaurants who have so passionately argued in favor of extending these contribute to the solution. I know they're busy, but they came out tonight, and maybe they can come out or write letters or brainstorm among themselves, maybe appoint somebody to come and talk to the city administrators about what their proposal would be. So that's my comment.
Okay. Any other comments from the commissioner on the motion? From the public? On the motion, Mr. Bongiovanni, go ahead. You have a comment on the motion?
Oh, hi. This is Kara Bongiovanni. I'm
sure.
From Luxembourg. That's okay. I just wanted to say, you know, I've been on this meeting all night, and it really seems that the restaurants are being highlighted to be bad guys, that we're really greedy and stuff. And I just want you to know that the public, if this was taken to the public, I guarantee you that the public would want this outdoor seating. They don't want to sit inside. If you limit us back to the 5 tables that we originally had with our plan back 10 years ago, that would put people wanting to sit outside on a 3-hour wait. I mean, it's just, this really isn't about greed or making money. And this conversation that you've had tonight really seems like about business. But honestly, you can come talk to any of my customers and they will tell you they want to sit outside. And that's really the bottom line. It's not about, we have been changing and working harder than we ever have in the last year to give the public what they want and what works and what's safe. And I have a lot of physicians that come in, regular customers, and one of my customers told me today, there's going to be another wave of this in the fall. Like, this is not done yet. And for us to take all these walls and roofs down, which costs us a lot of money, and then rebuild, it will be impossible. I mean,
thanks for your comment, Ms. Mangiovanni.
So I just really would appreciate, I would love it if you could take it to the public and let them be involved in this decision.
All right, thank you for your comment. We need to go to the vote as we're running out of time. Last comment, Mr. Bloom, on the motion. Mr. Bloom?
Yeah, thank you for letting me make a comment before you guys vote. There's been a lot of really good comment tonight on all sides, and making a decision is not exactly easy. I thought that, and I feel for everyone saying what they said. I thought that the comments earlier by the Fullers, in terms of people living downtown, which we're trying to get more of, and being able to coexist with the restaurants and the needs of the public to be able to dine in them, is also something that will need to be addressed for the future. In terms of Ms. Giovanni's comments, and this is why I raised my hand, she has to realize, and Stuart Sherman touched on this, the bistros were allowed to come into Birmingham under very different circumstances and bring in very inexpensive liquor licenses when other people spent hundreds of thousands of dollars, or at least $100,000, if not more, on a regular Class C license. So the bistros have benefited, and yes, if we want to help the public, but we also have to have some fairness in terms of the cost of the bistros. Now, if she would like to upgrade to a regular Class C license and pay an extra tax to the city for the privilege of being able to expand, that would be something I would support. Thank you.
Thank you for your comment. Last comment, please, Ms. Jessica Thomas. On the motion. Ms. Jessica Thomas, are you with us? You're muted, Ms. Thomas. Okay, well, Eric, can you help with the situation at all? We need to move on.
I
asked her to unmute.
Vote.
Ms. Thomas, can you hear me? Would you like to unmute yourself? I see your hand raised. You have a comment on the motion? Go ahead with your comment. Okay, we move on. I'm sorry, we could not hear you. So with that, will the clerk please call the roll on the motion in front of us?
Commissioner Sherman?
Yes.
Commissioner Huff?
Yes.
Commissioner Host?
Yes.
Commissioner Nikita?
No.
Mayor Pro Tem Long?
Yes.
Commissioner Baylor?
Yes.
Mayor Boutros?
No. Okay, motion passed. We go to item D. Well, I need a motion here because we ran out of time. We need to postpone item D probably in E and go to F. But Commissioner Sherman, go ahead with your motion.
I'm going to move that we postpone items D and E to the next meeting.
Second.
All in favor? I'm sorry, any comment? I'm too tired now. Any comment on the motion? Commissioner Host.
We're here on behalf of the people, and there's a lot of people here tonight for item D, and this would not be fair to them. So I believe we should continue until the public tells us to shut up.
Okay, any other comments on the motion? See none? Will the clerk please call the roll?
Commissioner Sherman?
Yes.
Commissioner Nikita?
Yes.
Mayor Pro Tem Long?
No.
Commissioner Baylor?
Yes.
Commissioner Hoff?
Yes.
Commissioner Host?
No.
Mayor Boutros?
Yes. Okay, now we have item F is a resolution to meet in closed session to discuss a written attorney-client privilege communication. And that would we would not be taking an action. And I need a roll call vote to go. Commissioner Sherman?
So moved.
So moved. All right. With that, will we have the roll call, please?
Commissioner Sherman?
Yes.
Commissioner Hoff?
Yes.
Mayor Pro Tem Long?
Yes.
Commissioner Baylor?
Yes.
Commissioner Host?
Yes.
Commissioner Nikita?
Yes.
Mayor Boutros?
Yes, thanks. We have item removed from consent agenda. It's all done. Communication, none. Reports, commission reports. Notice to appoint to the retirement board. Notice to appoint to the museum board. And notice to appoint to the Greenwood Cemetery Advisory Board. B, commissioner comments. Commissioner Sherman, go ahead with your comment.
I would note that we're already past our 15 minutes, so I would move that we go to closed session.
It's done.
Motion.
All right, let's go. Public, we would disappear for a closed session. We will recess and come back.
Mayor,
Commissioner Hoff.
I just want to say there's one announcement that should be made that we are going to return to in-person city commission and board meetings. I think that comment should be made.
Sure. You made it anyhow, so. Awesome. Okay. With that, we go to closed session.
Can you hear me?
Oh, so he's not joining us in the Zoom.
I can hear you, Tom. You need to join the closed session from the invite.
I did.
Okay.
Hold on.
Yeah, he's just asking. He's next to me. So should he be in or should he not?
I'm always in. I don't see where you join differently.
Okay. You know what? You can send that to me, and I'll take this. I got it. Easy. Thanks, Mr. Sherman.
Yes, Deb.
Hey, Eric. Eric.
Yep, what can I help you with? Yep.
Oh, hey. Yeah, not much. Just sent you a text. Hold on. Oh, you want me to hang around? Are they coming? Oh, they're coming back. Never mind.
Yep, they should be back shortly.
Okay, thanks, Eric.
Yep.
Don't forget to unmute yourself.
Okay, we got more than majority. Great. With that. Sorry about that. All right. With that, I think it's 11:15, and I'd like to adjourn the meeting. Have a wonderful night, everyone.
Night.
Good night.
Night.
Right.